Honorable members, Madam Speaker.
Prayer. Almighty God, we defend our prudential goodness of our appointed officers of leaders and parliaments for the welfare of certain just government of humanity. Beseech you to look upon with open favor to your servants, who have been pleased with the performance of such important tasks in this land. Let your blessing descend upon the assembled and granted the measure of your presence, to eat and control matters of human deliberation. Is so just and for the matter to promote your honor and glory, and to advance the good of those whose interests you have committed to your church. Communication from the chair.
Honorable members, I want to welcome you to today's sitting. But on a special note, I want to thank the team of the three who are always here in time. No, they're always here. I really want to thank you so much. As we are aware, the school term is coming to the end. The students are coming back home. And aware that we went through a very hard time during COVID time. Our young girls suffered through early pregnancies. I urge all members to advise their constituents on proper parenting. People should look after their children. That we stop blaming government on early pregnancies. Honorable members, I've also learned that His Excellency President has promoted our own colleague, Charity, to the rank of a brigadier. We want to thank the appointing authority and congratulate our colleague, Charity. Congratulations. I have a bill to process, and in this regard, we need to make sure that we move faster, because the first reports are straightforward, and we should be able to finish the bill, the electricity bill today. And remember, once we finish this bill, it will be something good for all the Ugandans. I want to thank you. Yes.
Right Honorable Speaker, I want to thank you for your communication, and I rise on procedure. Right Honorable Speaker, you have just communicated to us, and we are all aware that schools, most of the schools closed today and yesterday and then tomorrow. However, Right Honorable Speaker, this morning and afternoon, the whole town is blocked. Students are stranded in most of the places. The taxi operators and bus operators have hiked the price. For example, the normal transport from Kampala to my district, Bujiri, is always about 20,000, 25,000. This morning, they are charging students shillings. This comes in a time when parents cannot afford things. Right Honorable Speaker, when soap is very expensive, salt is very expensive, and now they are hiking the fuel prices. I mean the transport prices, especially for the students and the pupils who are leaving school, who cannot afford to go back home. So most of the students are stranded on the roads, and if you get out of here, you will see this showing that students are stuck and vehicles are not moving. Right, Honorable Speaker, would it be procedure right to invite the Minister of Transport or the Right Honorable Prime Minister to tell us and explain what are we going to do about the private transport owners hiking prices in such seasons, and also give us the future plan, because it's something that always happens. Whenever schools are opening and closing, you find the transport prices, the transport costs have gone so high. Would it be procedure right to invite them to give us both the short-term and the long-term issue once and for all, so that we don't have to have our children and students suffer on the roads and keep getting stranded? I thank you.
Government.
Thank you so much, Right Honorable Speaker. And I want to thank the members who has raised this. I want to be so honest, and some learning of it now, because I was in office so early. Let me inform the Minister of Works to see what can be done, either to do tomorrow. I beg for your indulgence, Right Honorable Speaker.
I think we should really take action on these private taxi operators. How can you start hiking prices for students who are going back home on top of the skyrocketing prices in the country, and you're also increasing prices? We need an action to be taken on those taxi owners. Yes.
Thank you very much, Madam Speaker. This is in regard to your communication that relates to the elevation of our very own Colonel Charity
She's not a brigadier.
to Brigadier. I really want to add my voice, Madam Speaker, to yours, and congratulate her, our honorable sister, upon that well-deserved promotion. And also, I meant to understand, Madam Speaker, that our honorable sister was also offered a new office. She's now the deputy SFC. And you know, when we get a woman in the office, Madam Speaker, like we do with you as a parent and as a community or as a country, we raise a lot of hopes. We're aware, Madam Speaker, that SFC and torture more or less had become kind of twin sisters, one preceding the other. And I hope that with Honorable Charity now heading that unit, the motherly heart and spirit will get into CFC, and then the way they relate with citizens will be civil enough. But most importantly, my procedure issue, Madam Speaker, I want to thank the appointing authority. Appointing authority, we have the Vice President, a woman. We have the Prime Minister, a woman. By God's design, we have the Speaker, a woman. We have IGG, a woman. What does this communicate, basically?
We are actually ladies, not women. We are ladies, not women. The chairperson of WOFA is also a lady.
Okay. You know, a woman means relates to a mother. But Madam Speaker, for your guidance, these are ladies. Ladies. My honorable sisters, duty calls upon you to put the issues of ladies or women, number one priority. The girl child. That with you in the office, we now have hope that basically the maternal mortality in this country will go down to zero, Madam Speaker. Because as I speak right now, statistically, a woman is dying in Uganda while giving birth. And I hope that now that we have our mothers in those very important offices, they will prioritize women and girls issues. That is my procedural issue. I congratulate all of my honorable sisters for those very important assignments. And we believe in you that you put the country first, you put the women first, you put the girls first for a better Uganda for everybody.
Honorable members, I want you to bear with me. I have 3 important reports that we must process today and finish. We must finish. 1, bear with me, we cannot have matters of national importance today, we'll have them tomorrow. And 2, those procedural matters, the orders. Can we have the report? Next item.
Item 3, motion for adoption of the report of the Public Accounts Committee, Commissions, Statutory Authorities and State Enterprises on the operations of the Uganda Railways Corporation.
Honorable members, the issue of URC of great concern. They arise from the termination of employment, failure to secure the land, mismanagement, and maladministration. And this, in 11th Parliament, this is the first report that we are getting in regards to the challenges that URC is facing. I urge you members to listen carefully. They have very good recommendations and direct. I now ask the chairman to give us a brief on the report. We've had this report for over 2 weeks.
Thank you, Madam Speaker. Actually, we've had it for much longer, but Parliament had to go through the process of sending off our leader. Madam Speaker, I stand to present the report of the Public Accounts Committee on Commissions, Statutory Authorities and State Enterprises, Fossa, on the operations of the Uganda Railways Corporation. And before I proceed, I beg to lay on table the report.
Please do.
Madam Speaker, with your permission, I also beg to lay the minutes of the committee meetings that led to this.
Okay.
As you have mentioned, Madam Speaker, we paid specific attention to land belonging to Uganda Railways Corporation, locomotives, staff welfare. Those are the issues that we dwelt on. For want of time, I might skip 1 or 2 things, but the salient issues I will endeavor to read. So there's a bit of an introduction. I'm not too sure I should go through that. Maybe the methodology in undertaking our task. We held meetings with the board and management of URC, workers of URC, the privatization unit. We also did have an interface with some of the land beneficiaries. We also had with us the Minister of State for Investment in the Ministry of Finance. We also carried out a field visit, Madam Speaker, to the workshop of the URC in Nalukolongo on Kampala-Masaka Road, and also made reference to several documents. The first issue, Madam Speaker, is URC Land Matters. The committee inquired whether URC had in its possession all its land titles and whether the said corporation land was free from encumbrances. URC management informed the committee that the corporation had most of its land titles, as evidenced by the schedule of the URC certificate of titles. However, several pieces of the corporation's land are encroached upon throughout the entire network. Further, the corporation was the registered proprietor of land and property comprised in different freehold register volume, leasehold, and sublease register volume, and Milo land, which was originally owned by the East African Railways and Harbours Administration and the East African Railways Corporation. I want to skip a bit of these issues. In doing our work, Madam Speaker, we assigned some of our members, a small team, to dig up further on land matters, which we later, of course, discussed as a committee and adopted this report. One of the issues that we interrogated as a committee was disposal of land. The Public Enterprises Reform and Divestiture Act and Divestiture of Public Enterprises and established the Divestiture and Reform Implementation Committee. It was this committee that implemented the privatization process. This act provides for 4 classes of enterprises. URC was put under class 2. Now, these are enterprises in which government retained by way of a 25-year concession to RVR effective 1st November 2006. URC remained in existence as the regulator and RVR became the concessionaire. URC assets were earmarked as core and non-core assets, the core assets being vital for rail business operations and the non-core assets being mainly assets used for accommodation by staff. Use of proceeds from the divestiture. According to Section 26, the Minister of Finance may use the proceeds to meet the costs and expenses associated with termination of contracts of employment in the different public enterprises under classes 1, 2, 3, and 4. Under this same provision, government took over the liabilities of the enterprises. The proceeds, not used for present and future costs, were to be transferred into a redundancy account and to be used for promotion of Uganda entrepreneurs for agriculture and industrial development. The disposal process, which we had issues with. So the disposal process of URC assets was implemented by Privatization Unit, PU, as directed by the Divestiture Reform and Implementation Committee in accordance with Section 22 and the second schedule of the PAD Act. PU, in consultation with URC, formed a task force composed of officers from PU and URC that enumerated all URC non-core assets and prepared an inventory of the same. PU gave the first offer to the sitting tenants, and where they were unable to purchase the properties, they assigned their rights to third parties of their choice. The properties were sold on an as-is, where-is basis. Where these properties were not disposed of, the interest reverted to URC. A sample of the offer letter drafted by PU was availed to COSASE. Now, whenever someone accepted an offer and paid up for a property, PU furnished URC with, the required documents and receipt of proof of payment for purposes of execution of a sale agreement and transfer reforms. Now, we observed a couple of issues therein, Madam Speaker. Number one, there was non-compliance with the provision of the Public Finance Management Act on asset management and inadequate report on the status of the assets. Number two, the reports on status of URC's land that were submitted to the committee were irregular since they lacked the period, years that they were compiled, and was not regularly updated. So there was no. 3, URC has a weak capacity to monitor, utilize, and protect its vast land that stretches from Kasese to Malaba and to Pakwach. Now, we made recommendations regarding this. The land issue is a lengthy one, so we broke it up in B. You should swiftly move to start negotiations with those who lawfully acquired interest in the railway land with the objective of having them compensated within the meaning of Article 26 of the 1995 Constitution. Number 2, URC should engage an independent firm to make an inventory of its land. It's important that they get to know how much land they have that belongs to them. 3, URC should put in place mechanisms to enhance capacity to protect and utilize its land. Now, moving to properties that were disposed of under phase one, because this was done in phases, Madam Speaker and honorable members. Under phase one, the following non-core assets were sold between 2007 and 2009 and concluded in 2010. All properties that were not disposed of under phase one were transferred to phase two for possible disposal, which we shall look at. Now, there's a table there which indicates the properties disposed of under phase one. Our observations: number one, the criteria that was used to classify those assets as core or non-core was not clear. As the assets were core assets. Some properties were classified as core, while others within the same locality were classified as non-core. For example, plot 122, block 264, Chadondo, Mutundwe, and plot 2733, Chadondo, Mutundwe. What this means, Madam Speaker, is to say that this property is non-core, so we must be able to sell it. But then, just adjacent to it, there's another property, same area, same usage, and then they say, no, the other one is core, this one is non-core, so let's sell this one. And we credit that. How do you say the other is core and this one is non-core? So we must be able to sell it. Two, the committee noted that only 10 out of 15 properties were advertised. There's no evidence to show that those which were not advertised were sold through the right procedures. This is government land, Madam Speaker, and so for it to be disposed of, for it to be sold, there are procurement processes that have got to be abided by. So one of which is advertising. So they only advertised 10 properties, but they eventually sold 15. So how were the other 5 sold? That was a challenge. Number 3, there was no evidence of payment for these properties. 4, there was no evidence of a valuer's report determining the reserve price. In that particular regard of phase 1, because there's phase 2, we advise as a committee that the Inspectorate of Government should investigate this matter and prosecute all those found culpable, because government land cannot be sold without following particular procurement procedures, receipts not availed, and so on.
Just a minute before you continue. Did the Minister of Transport know that this report was coming today? Because what is being raised is really very important issues for his ministry.
Right, Honorable Speaker, the Office of the Chief Whip, somebody has gone to the ministry. I'll report whatever decision they've taken, whether to do tomorrow, within an hour's time.
No, what I'm saying in terms of this report of URC.
Still, I've told them to come because this report concerns the Ministry of Works and the Ministry of Finance. The Ministry of Finance is here represented, but also somebody from the Ministry of Works have already requested them to immediately send somebody.
Okay.
Thank you.
Thank you.
Madam Speaker, properties disposed of under phase 2. Under this phase, the privatization unit in July of 2013 contracted SM Cathan Property Consult and CB Richard Ellis joint venture to provide consultancy services to subdivide Uganda Railways Corporation's estates, register, create titles, and value the new plots, which included land and buildings. The assets are located within the towns of Tororo, Gulu, Masindi, Jinja, and Kampala. The valuation reports were sanctioned by the Chief Government Valuer, and there's a report including the properties that were earmarked for subdivision. That's table 2 of the report. It is worth noting, Madam Speaker, that even under phase 2, all the non-core assets in Gulu, Masindi, Jinja, and Tororo properties that did not require subdivision were disposed of on an as-is, where-is basis. Anomalies arose from the second phase, where certain properties were sold to third parties by sitting tenants who were given first priority, that transferred their interest to third parties and whose interest could not be regularized by URC. Our observations, Madam Speaker, the committee observed that there was no evidence of payment for the properties above. So again, properties are sold off, title changes, but there's no evidence that actually these properties were paid for, and this is government property we are talking about. Number two, there were anomalies in the disposal process which resulted into several litigations which could cause financial loss to government. Many people went to court over these matters, Madam Speaker. And for this particular issue, we recommend, one, the officers in the privatization unit that handle this process should be held responsible and punitive action taken against them. Because when you handle a process of selling government land, but you don't provide evidence of payment, where is the money? So that's why we are saying action has got to be taken against these individuals. Number two, URC should appoint an independent legal firm to verify the claims with a view to settle and resolve these matters. Now, there are those with claims and so on. So we are saying some matters URC should handle out of court. It will be less expensive at the end of the day. Now, the other issue is the disposal of URC land at Nsambya. Arising from a presidential directive and a cabinet decision, which is attached, marked Annex A in the report, Nsambya land, formerly owned by URC, was transferred to Uganda Land Commission with assurance that government would pay URC for this land. However, URC has been persistently engaging the Ministry of Finance, Planning and Economic Development for compensation to the sum of 69.5 billion to no avail. That was the value of this land. In the latest update, the Minister of Finance directed the PSST to effect payment, and there's a copy of the letter. But of course, that money has not been paid yet. Government cancelled the land titles for local investors in the Naguru Nakawa estate to allow development of a satellite city by OPEC Prime Properties. These local investors challenged the legality of the transaction, and government agreed to settle out of court and compensate them with land elsewhere in the city. URC land in Zambia was identified for this purpose. Here are observations through this process, Madam Speaker. Number one, despite the fact that the presidential directive and the acres to be allocated to the above beneficiaries, 72.78 acres is what was allocated, bringing an over allocation of 40.43 acres without authorization. So we are saying, who authorized this extra? Because the presidential directive and cabinet memo talked about 32.35 acres. But the people who are handling this process decided to allocate a lot more, whether to themselves or whatever the case might be, but there's an over allocation of 40.43, a lot more than what the directive was, Madam Speaker. Number two, some beneficiaries that were included in the presidential directive and cabinet memo, Annex A, were denied land. For example, National Library, 2 acres, Nakawa Disabled Vocational Training Institute, 0.6 acres, Quakers, 0.43 acres, and the Church of Uganda, 0.39 acres. So there were those who should have benefited, and they did not benefit. 3, some individuals and entities were not meant to be beneficiaries, but they were allocated land, Madam Speaker. For example, Kampala International University, which did not appear in the cabinet memo and the presidential directive, was allocated 14 acres for the development of the university. However, as we speak, Madam Speaker, a shopping mall called Arena Mall was eventually built on the said land. That's problematic, Madam Speaker, because number one, they were not meant to be beneficiaries of this land. But then eventually, they were given land to apparently develop the university. But today we see a shopping mall on this land. The taxpayer was shortchanged, as far as we are concerned, Madam Speaker. Number 4, the committee noted that some individuals and entities did not pay premium or ground rent for the land that was allocated to them. For example, the lease for Miss Janet Kovusinje, the proprietor of Miss Steele Hotel and Residences in Zambia, was extended from 10 years to 49 years, and then to 99 years with no premium whatsoever or ground rent paid for the 89 years. This was contrary to the law and the terms of the consent judgment. The consent judgment did not waive the requirement for payment of premium and ground rent on public land or the need for due process to be followed in extension from the initial grant of a lease of 10 years. Madam Speaker, for clarity, Ms. Janet Kobusinje was one of those who had been given titles in the Naguru-Nakawa land. So when they were in the consent judgment was avail to them land somewhere with a lease of 10 years. That was the consent judgment from court. But then, eventually she was given a lease of 49 years. What that meant is she had to pay premium for the extra 39 years. She did not pay. And then the 49 years were now increased to 99 years. There was no premium paid. So we are saying the 89 years extra should have been paid for, but she did not, Madam Speaker.
Just for clarification, the extension of from 10 to 49 to 99 was within what period of time?
It was pretty much in the process of, her getting to acquire possession, the leasehold possession.
The interval of time?
The interval of time. It was around the same time, Madam Speaker. Everything was done quickly. So she has got a lease of 99 years. But then the consent judgment was 10 years. So nothing stops her from acquiring whatever number of years, but then you have got to pay the extra 89 years. There was no evidence of that, Madam Speaker. Our recommendations, Madam Speaker. The committee recommends that the Ministry of Finance, Planning and Economic Development should ensure that the proceeds from the URC land at Nsambya of 69.5 billion should be prioritized and released to URC in the next financial year, 2022-2023 budget. Because the agreement was URC surrender this land to government because there are people who want to compensate. We 5 billion. And to date, that money has not been paid. URC is struggling with many other challenges, paying staff and so on, and yet government owes them money because of this land that was eventually given to several people. Number two, Madam Speaker, the Uganda Land Commission and the Privatization Unit should be held responsible for the anomalies that transpired in the allocation of URC land at Zambia, because URC handed over its land and titles to Uganda Land Commission. So Uganda Land Commission is the one that dealt with the parceling out of these properties in conjunction with Privatization Unit. And so we are saying, Madam Speaker, things like this should not happen, and it's okay. It's not okay. Action should be taken. Then people will know that you have got to follow processes. You don't sell land and then get payment, keep it to yourself. You don't avail this payment because this is not your individual money. It is taxpayers' money. Issuance of illegal leases over land belonging to Uganda Railways Corporation, URC. Over time, district land boards in Kampala, Jinja, Mbale, Gulu, Nwoya, etc., and the Uganda Land Commission have created illegal leases over URC land. Several requests by URC to these land boards to cancel the said illegal leases have been futile. This has made it difficult for URC to recover its land. URC has written to these bodies and the letters have not been responded to. Some of them have been added as parties to litigation cases involving URC, and there's a matrix showing these details. Our recommendations, Madam Speaker. All illegal leases on URC land should be cancelled by the issuing authorities because they're in the district land boards involved in issuing these illegal leases should be held responsible because what they're doing is illegal. So action has got to be taken against them, Madam Speaker. Number three, URC should come up with clear mechanisms on how to lease its land so that the appropriate value of the assets can be ascertained. When it's done in a haphazard manner, that's when everybody now will grab some land for them, the other will pay less for the value, etc., etc. Madam Speaker, the other issue that we interrogated was locomotive engines. The committee inquired from management about the inventory list of locomotive engines for the corporation, the status of operation, engine capacities, location, and whether they possess fuel registers. The committee was informed that URC maintained a fleet of all locomotives under its use, indicating the status of operation, etc., etc. Further, the corporation maintained a fuel register. On further scrutiny, however, the committee made the following findings. 4 locomotives were purchased in August 2021 at a total of 48 billion shillings, but since they arrived, they had been parked in the workshop with no work. The URC workers interfaced with the committee at the time and revealed that the locomotives were imported without knowing that they were too long for the triangles and not able to turn. These are dynamics of railways. The workers of URC also stated to us in our committee that the technical staff were not consulted prior to the commencement of the procurement of these locomotives. Now, this was not a requirement, really, but they were saying, you know, it's just a good thing because the bosses take the decision. But it's just good manners to inquire from the juniors, quote unquote, what do you think? Give us some advice, because they're the end users. And so they thought maybe if they had been consulted, they would have been able to give some advice. Number 2, the Uganda railway line of 50 to 80 pounds would not be able to handle the weight of the new locomotives, which required that it runs on a 90-pound railway. C, the motors which propel the locomotives are very low and that they were unoperational on Uganda rail lines. These are issues that we found. URC management responded that the corporation was making modifications to the triangles on the rail lines to enable the locomotives to move smoothly, and that this would be completed by 15th November 2021. They were not able to hit that deadline because they acknowledged that they needed to make certain changes on the rails for these locomotives to operate with ease. So they gave us a deadline, they didn't hit it, and so on. They further stated that the locomotives had been procured with additional spares for 3 years, and the line was fit. However, the turning points were narrower. This was an admission by the management of Uganda Railways Corporation. The committee was informed that the locomotives would only serve Kampala, Malaba, and only the turning point would be modified. The committee made the following findings, Madam Speaker. After carrying out a market survey, a URC select committee recommended that the company purchases locomotives which are 6 years old at 36 billion. However, locomotives which were 8 years old, costing 48 billion, were procured. This is problematic, Madam Speaker. A select committee put in place, made contacts and so on, and the recommendation they gave was, look, we have identified locomotives that are 6 years old, costing 36 billion. But the people who purchased, Madam Speaker, bought older locomotives and more expensively. It doesn't even make logical sense, Madam Speaker, because what is older should be cheaper. And this was their information, because they're the ones that put in place the select committee, which made all these recommendations after doing market research. 2, the committee notes that this was odd because older yet more expensive locomotives than those recommended were purchased. Management stated that of the 48 billion earmarked, 42 billion was for the locomotives and 6 billion was for rich takers. That's some technical equipment added to that. Our observations, Madam Speaker. The Ministry of Works and Transport deviated from the government policy of procuring new equipment and recommended and approved the purchase of used and refurbished locomotives, because the approval came from the ministry. Number 2, the procurement and disposal unit and the contracts committee of URC recommended open international bidding because of the amount of money involved. However, management opted for restricted international bidding without proper justification. So again, the procurement and disposal unit and the contracts committee of URC said, look, because of the monies involved here, let's not get ourselves in trouble. Let's do open international bidding. That's what is required. But then the people who actualized this decided, no, we shall deviate from what our committee has advised, and we do restricted international bidding. So they went for a particular individual they bought older, yet more expensive locomotives, Madam Speaker. 3, URC had to incur unplanned costs of modifications to improve the triangles and to provide turning points for these locomotives. Number 4, the compatibility of the locomotive prior to procurement. So we are not saying these things, cannot happen, but you see, it's important to cross every T and dot every I. Before you make a purchase of this magnitude, first do your homework. We don't think they did their homework. Our recommendations, Madam Speaker. 1, the Ministry of Works and Transport should take responsibility for failure to follow the government policy on procurement of equipment. Number 2, the management of Uganda Railways Corporation, which was involved in the procurement, should be held responsible for flouting procurement regulations and the unplanned costs incurred on modifications of railway. So you didn't do homework, you're costing the taxpayer money. Modify here, modify there, and so on. But 2, you did not follow the procurement guidelines, which were even advised by your own internal committee. We feel that, Madam Speaker, these things should not be overlooked. People need to know that you've got to do the right thing because it is taxpayers' money we are talking about. There are regulations that have got to be followed. The other issue we inquired into, Madam Speaker, was Nssf remittances. The committee learned that URC had not made remittances to Nssf for 2 years, and the workers were concerned that this would affect their interest, which is meant to accrue to them. So the committee observed that over 2.8 billion shillings is still pending as Nssf arrears, although payee had been cleared to date. URC prioritized and remitted payee without remitting the obligations of Nssf, and yet both are statutory obligations, and they're both equally important. Because you see, one way of motivating your staff members is not just a good salary, but Nssf, it is their money. When they retire, they should retire to this money. Our recommendations, Madam Speaker. Number 1, the committee recommends that URC management should prioritize remittance of Nssf, since this directly affects individual employees who are missing out on an annual interest and on the outstanding Nssf remittance. And URC should ensure that the outstanding Nssf remittances should include interest, which should have been earned by the employees. Madam Speaker, when this money is not remitted, the workers lose interest for that year. So even when you eventually pay it, I don't know how many years, if they eventually pay it, it will be minus the interest to these workers. That's not fair to the workers of this country, because they will have missed this interest for I don't know how many years. So even if you get that lump sum and you give it to them, it is minus a lot of money which they should have earned as interest. So we are saying that should be catered for. Remit that money, but with interest. Besides, these are your employees. When they are incentivized, they'll do a good job. 1, you're paying them little money, but 2, it is minus, a critical element that, like Nssf. So we feel that should be addressed, Madam Speaker. I'm on page, somebody's asking which page? I'm on page 12. I'm getting to the conclusion. Our conclusion, Madam Speaker, URC management should oversee their assets better, given that they have the potential to generate resources that would enable the smooth running of its operations and activities. The board of URC, as required by law, should pay keen interest in the affairs of URC and always provide appropriate guidance to management to enable the entity to effectively carry out its mandate. It's our prayer that the committee report be adopted. I beg to submit.
Thank you, Honorable Chairperson of Fossa. And as you've noticed, we are dealing with another government agency which is riddled management, land issues, Nssf remittance, And of course, you know, it disadvantages the beneficiaries. Because if you're not remitting NSSF, then the interest will not be got by the beneficiaries from NSSF. And even when I used to be in Fossa with the Honorable Katuntu, URC has had all these problems. And from the time we presented our report, no treasury memorandum has come out. How I pray this time around it comes out, because we need these things resolved. The report is here, ready for debate. Can we first hear from the minister, from the two ministers?
Madam Speaker, I did appear before the Committee of Kusase, and my position as the Minister of Privatization, this time not investment. And I do agree with the recommendations of the committee. Madam Chair, particularly on the issue of 69.52 billion that government has to pay as compensation for the Nsambia land. I did commit to the committee when I appeared that government undertakes to make good of that obligation. And I went back to the ministry and wrote a letter to the Permanent Secretary of Finance and Secretary to Treasury on the 10th of February, requesting that the money 69.524 billion is made available. Madam Chair, it is the understanding of Ministry of Finance that we have to make good of this obligation and therefore pay this money to URC. Due to competing, get this money again in the financial year, but since we are in the process of budgeting, the understanding of my ministry is that when we get more money through tax collection and other sources of resources, we will be able to pay this particular amount of money. We commit as government to pay the 69.52 URC. I'd like to submit.
Honorable Minister, what's wrong with you including that 69 point something in the next financial budget? The budget process is still ongoing. Or have you included it?
Madam Speaker, as the process is, my job as the minister is to write to the Permanent Secretary and to include this. I did that on the 10th of February, and the response was that we do, because of competing priorities, we're not able to get this money, and therefore it was not included in the budget. But Madam Speaker, if the wish of Parliament is that we have to put it here since we're in the budget process, then we will put it as underfunded priority, and when resources are available, then we'll be able to make good of the payment.
If it's a legitimate claim, then why don't we budget for it? I mean, we're in the budgeting process. Yes. So include that in your budget.
Right, Honorable Speaker, I have looked at the report presented by my very eloquent colleague, and indeed, the report is very comprehensive. And I have, first of all, on the onset, I want to let this House know that the Uganda Railways Corporation is a very critical sector, very critical agency in the transport sector. And
I also want this house to know that indeed URC suffered a lot of ills in the last so many years, and all those ills were managerial in nature. I want to request this house to allow me to go back to my two colleagues after the debate, and we prepare a very comprehensive response to this house, indicating all this and particularly capturing areas where we have made interventions, so that together as a ministry and this honorable house, you'll be able to appreciate how far we have moved. After appreciating how far we have moved,
Procedure matter from,
clarification, Madam Speaker.
there's a procedure matter from Asman, then Mehdi.
Speaker. Madam Speaker, the minister has been on the floor and in her own words did the report as presented. The report now is before us, where the other side concurs with the contents of the report. She was particular, even she said, I agree with the recommendations. Yes, she said she agrees with the recommendations. Would it be procedurally right for the minister to say they are going back to present a response, and yet they have already said they agree with the recommendations? Would it be procedurally correct?
Who is a treasury memorandum? Who will adapt this report? And you will come with a treasury memorandum on what actions you've taken. And that is final. You're not going to start revising this report and say you're coming back to give a response. We are going to give you 6 months to present a treasury memorandum here. Yes, Mehdi?
Thank you, Right Honorable Speaker. Right Honorable Speaker, this report is a report of Parliament. And every member here has a stake in this report. And in this case, we've not processed the entire report. My view, Right Honorable Speaker, and my humble prayer is let's exhaustively debate this report, adopt it whether with amendments or anything otherwise. Then we can come up with recommendations that can bind the minister to present. But if we make a ruling, it will be putting the cart before the horse now.
We are not putting any ruling. We have not stopped any debate. We wanted to hear from the two ministers who are responsible. Minister of Finance, who has accepted that the recommendations are okay. She even appeared before the committee. Now I wanted to hear from the Lines Minister, who is Minister of Works, who is not sure. So we debate the report and adapt it or reject. Yes, Honorable Baka.
Thanks very much, Madam Speaker, and I want to thank the Minister of Finance for accepting the recommendations. And when we were mentioning about ways on how we are going to look for the monies to be refunded to URC quickly, the issue of Nssf, which is mandatory, and where you know very well that we are in the process of giving mid-term, you did not indicate it. The workers were contributing that money, and URC was keeping it. What are you saying about the monies that has already affected the workers as we talk now? Because they can't get the exact percentage of mid-term if that money is not funded quickly. Can I get the answer from the minister?
Honorable Baka, there is a law to that effect. And the law will be used on that. Honorable Minister, have you finished?
I think, Madam Speaker, given your guidance, let's go into, let the members enrich the report by debate, and then I will absorb some of the issues that the members on top of this. Then we shall see how to proceed. But I can assure you, Madam Speaker, that given the fact that we haven't studied it thoroughly as a sector, there is need for us to appreciate, first of all, the details before we give a comprehensive response. But I am ready for the debate.
Honorable Minister, did you interact with the Minister of Works? You did?
Madam Speaker, the Senior Minister of Works himself, General Katumba Amala, came to the committee.
Okay, thank you. Now we open it to a debate. Mehdi,
Thank you, Right Honorable Speaker. Right Honorable Speaker, I would like to thank the committee for the job they did. Right Honorable Speaker, I'll make reference to the following in enrichment of this report. The committee on purchase of locomotives clearly states that in its findings, it discovered through research that the prices of the locomotives acquired were higher. I'm not here to disagree with them, but I'm only asking them to give us their reference for this research, to clearly state as to whether what they bought costed this and what is on the market is this, according to this cross research that we have. That is one. Two, the instruction for cancellation of titles cannot come as a recommendation from Parliament. Why? Under the Registration of Titles Act, cancellation of titles, with a few exceptions, is the preserve of High Court. Can I go on, please? So the recommendation would be, in this case, that where it's found that there was fraud or there was any entry made erroneously, then this Parliament can recommend that. And that is the law. That is the law.
Thank you, Madam Speaker. Right Honorable Speaker, with due respect to Honorable Nsereko, who is not a member of the committee that investigated, and the committee came out with its own recommendations, and on several occasions we have had reports here where a committee recommends cancellation of titles. Unless Honorable Nsereko is telling us that is an interested party in the land of Uganda Railway Corporation, is in order, Right Honorable Speaker, for Honorable Nsereko to begin putting in his own recommendation, watering the recommendation of the committee, which is in the interest of the committee as you directed, Right Honorable.
Honorable members, the committee is urging the responsible institutions. We are not counseling as Parliament. It is saying the responsible institutions must take an action on it.
Before I was rudely interrupted by the member, it is a recommendation of this august House. And if you're not recommending to a particular directorate to interest in itself in the cancellation. The powers belong to the High Court, and therefore it all remains redundant. Thirdly, as regards the funds were transferred by those that paid premium, the 69 billion. It's not compensation to finance. And finance should only tell this parliament where this money is. We are not talking about compensation, Right Honorable Speaker. Those that paid the premium after advertisement paid 69 billion, in lieu of which these funds should have been given to Uganda Railways Corporation. The issue in question here is, where are these funds from finance? It's not about compensation. And what were these funds used for? So I would not like us as a parliament to interest ourselves in a matter of compensation which is inexistent. It's misappropriation of these 69 billion. That should be the question. Thank you, Right Honorable Speaker.
There is an aspect of money which was supposed to be paid for the land which is sold, purportedly being sold, and the money cannot be accounted for. They cannot know where the money was put. And then there is also money that was supposed to be for compensation from finance, which has not reached URC. Yes.
Thank you very much, Madam Speaker. And I want to thank the chair for the great job. First of all, I really want to bring it to the attention of my honorable in-law that I'm a little bit disappointed, in a sense that you serve the same government or same.
So we have in-laws in this house, eh?
Honorable Minister Echero, I'm a little bit disappointed this afternoon by the fact that your colleagues from the same system, your work or your roles are supposed to reinforce one another. Madam Minister did indicate that she had no problem with the report. And I thought, as a family in a government system, if you had views to the contrary, I think that should not have been brought to the surface. I just wanted to make that crystal clear to place before your attention my disappointment. Madam Speaker, corruption is bleeding this country, Uganda, to death. According to the 2021 IGG report, in 2022 IGG interim report, headed by an officer appointed by the president, this country loses up to 22 trillion shillings to corruption. 22 trillion shillings. And I'm quoting IGG report. Madam Speaker, from the 22 trillion Uganda shillings lost to corruption every year, 1 trillion is lost to procurement fraud alone. Here we are.
2 minutes, 2 minutes.
Yes. Here we are, Madam Speaker. We have our teachers that cannot be paid. Health workers, we cannot pay them. We have hospitals that are not well equipped. I really want to thank the committee and the leadership of the committee. Time is now, Madam Speaker, because we'll be confronted with one question: what did you do? Any report that leads to money or brings to the surface or discovers corruption somewhere, I think it is up to, we have to answer the duty that this money that belongs to the taxpayers must be recovered. And I want to support the recommendations, and that the money that are being pointed in the direction of corruption must be recovered, including those that are responsible for the loss. I want to appreciate it, Madam Speaker.
Thank you very much, Madam Speaker. Madam Speaker, I want to thank the committee for the report they have presented, and I will interest myself on a few issues. So, as far as the railway to this country is concerned, that is from the Kenyan border. And Madam Speaker, it is in our interest that this infrastructure operates to the best of our ability. But unfortunately, in the purchase of the locomotives, I am a procurement specialist myself. I think technical specifications were not observed. And we need to really get the culprits who were involved in making these specifications to tell us what they really came up with. Because you buy 5 locomotives, and these locomotives are not compatible to our railway lines here. So it means there that we were not organized enough in our planning and going for what would help us solve the problems. Madam Speaker, as I said, I represent Kilometer Zero. Now, on the other side, the Kenyan side, we have got the standard gauge railway. But we have also got an improved railway from Naivasha up to the border. And Madam Speaker, the jam that is currently on the Kenyan side of Malaba, because of the so many containers that are delivered by the railway on the other side, has made us get sleepless nights at the border because of congestion and the inability for our railway to evacuate the cargo that is coming from that side. And this is arising from the wagon, I mean the locomotives that should have been good enough for us to ensure that the movement is good. Madam Speaker,
there is a procedure. And what Honorable Angora is saying, on top of non-compatibility of the locomotives, there was also a wasteful expenditure. 36 versus the 48. What is the justification? Yes.
I raise on a procedural matter. When we are talking about prices and falsification of prices, and the Honorable talked and told this Parliament that he is a specialist in procurement, when you bring facts on table, you have to give us that this comes from here compared to this, because you must compare two facts. You don't just come and speculate and say that this was expensive. For us to understand as Parliament, we must have a good comparison. So what I wanted to raise, the procedure matter was raised.
There is a report of the select committee of URC that recommended that the locomotive that was supposed to be bought was 36 billion, but they went and bought the one of 48. Why don't you read the report?
thank you very much, Madam Speaker. Madam Speaker.
There is a motion on this side. If you know your conflict, don't discuss this report.
Motion. Yes, Madam Speaker.
There is a motion.
Madam Speaker, I beg to move a motion. Madam Speaker, I beg to move a motion that the House adopts this report as it is, and we give 6 months for government to bring a treasury memorandum on this report and even all that are pending, because URC is a very serious matter. I beg to move.
The motion seconded. The motion is seconded. Don't shout.
This is not a market.
Don't shout.
Chair, I beg to move an amendment to 3 months.
Yes, we are the amendment of 3 months that we receive a treasury memorandum. Is it seconded? It is by law. By law is 6 months, not so. Let's not go against the law because of the urgency. Maximum of 6 months. Yes, by law it is maximum of 6 months, but we can even receive in 1 day. Yes.
Thank you, Right Honourable Speaker. Allow me to thank
Honourable members,
full job. Madam Speaker, these are the kind of reports that will define the 11th Parliament. And the bipartisan approach to this report is very encouraging of this Parliament, Right Honourable Speaker. But I rose to amend the 6-month moratorium, bearing in mind, Right Honourable Speaker, that there are other consultation reports for which no treasury memorandum was provided. As part of the requirement to comply, and aware that even over the last reports, no treasury memorandum was provided, we ask, of course not with menace, but as a way of admonishing those responsible for providing treasury memorandum for not giving us prior treasury memoranda, to give us this in 3 months. Because initially, they were not compliant to the law, so they are not asking for us to comply with 6 months because their hands are not clean. Having failed to be compliant a priori, this time around, they should give us not only the new one, but even the old one in 3 months, Right Honourable Speaker, that we can really enforce compliance and respect to the law and Parliament. I beg to submit.
Government.
Madam Speaker, if the law says at most 6 months, it means even 3 months, even 4 months can apply. And if this House, in its wisdom, thinks in 3 months we should come here, who are we to challenge the House? We shall go back, we shall put our heads together, we are a system, we shall be back here.
Thank you so much. Honorable members, I now put a question that the report of Public Accounts Committee on Commission, Statutory Authorities, and State Enterprises on operation of Uganda Railways Corporation be adopted by this House. Those in favor say aye, and to the contrary, nay. The ayes have it. We need a report in 3 months. Treasury memorandum. Next item.
Item 4, motion for adoption of the report of the Committee on Rules, Privileges and Discipline on proposed amendments to the rules of procedure of the Parliament of Uganda.
Honorable members, since the beginning of the 11th Parliament, there have been referrals to the Committee of Rules, Privileges and Discipline on proposed amendments of rules of procedure. As we are aware, the rules are the living documents that ought to reflect the dynamic arena that the legislature is on. Honorable Chair, can you come and present? Members, as I told you, I want you to be mindful, we have a bill that we must process today.
Well, thank you very much, Right Honorable Speaker. Right Honorable Speaker, I beg to lay on table the original reports signed by the minimum number of members required, together with the minutes of the committee. Beg to lay.
Ms. Lay, thank you.
Right Honorable Speaker, on the 19th of October 2021, before I present the report, this House amend particular aspects of the rules. Looking at the answer at both page 42 and 45, the presiding officer then let it, and I quote, "Thank you, honourable members. What we are doing at the moment is identification. I see Honourable Katuntu is rising, but I don't know on which point he's raising. At this stage, we are doing identification of the problematic areas so that when we make reference to the committee on rules, privileges, and discipline, we give them guidance. Otherwise, we are not going to start from rule 1 to the last. It will not work. We know the problem areas, and so we are going to identify them so that by the time we make a formal reference to the committee, they will be properly. He emphasizes that also on page 45 when he directs. Let us do the identification properly and then we do a formal reference to the committee. I think now is addressing me. I think you stay what you have done now. Let us add you more and then you build on it so that we have you are comprehensive in what you are doing, you are going to do, Chairman of the Rules Committee. So, Right Honorable Chair, Right Honorable Speaker, for a long time, we've been waiting to have the guidance and identification of the problematic areas which this House has not done. And that has led to this committee not to be presented in the 45 days because literally there was a stay by the presiding officer or by the House. That also answers the leader of opposition's letter to me because he had asked what happened. I'm sure at that time he hadn't addressed himself to what the House had directed, that we stay reporting. Sorry?
Right Honorable Speaker, thank you, Honorable Katuntu. Right Honorable Speaker and honorable members of the House, I seek your indulgence to allow us an opportunity to defer this matter to tomorrow. I am only getting an opportunity to look at it now, and if my colleague will be pleased to allow us just to read it and come back tomorrow so we can proceed on it. I seek your indulgence, Right Honorable Speaker and honorable members of the House.
Thank you, Right Honorable Speaker. Of course, I have had occasion to look at the report of the committee. And of course, I have a bit of challenge with the report. Not that I disagree with the fundamental contents of the report, but you are aware, Right Honorable Speaker, that this committee does not work like other committees. It only works on referrals of the House, and it's rarely interactive to seek the input of evolve. I do not know whether it would, in a way, deter the House from doing work on time. And I want to a bit agree with the Land Attorney General that this report would stay to allow the opposition in the Parliament, with the indulgence of the Speaker, not to prepare, but to interact with the leadership of the committee on what we had considered as the import initially of my motion. And I want to be sure, because I never was given occasion to really speak to it in the committee. I do not know whether they answered. I'm not trying to fault the answered in any way, but I want to be sure that was properly recorded, and the import of what I've seen in the rules, that we are on the same page with the Land Attorney General and the chairperson of the committee, who did a good job. The land chairperson at that, right, Honourable Speaker. So that these are our rules, right, Honourable Speaker, and they are speaking to the issues that are going to make our work smooth, so that we do not work acrimoniously. If you saw, if it pleases you, right, Honourable Speaker, that this report be stayed to allow an interaction of the opposition in Parliament with the leadership of the committee. Unless the chairperson has an objection clothed in law, I would then hesitate to push it further.
Can I hear from the chairperson?
Thank you very much, Right Honorable Speaker. Colleagues, these rules govern the way Parliament conducts its business. And if we don't address them comprehensively, logically, then the way we do our business may be affected. So if any colleague would want to have an input or a considered opinion, I would not have an objection. Why should we? Because this is supposed to help us to do our work. So to me, I don't have any problem. I also want to reply, to give a reply to the leader of opposition. I know where it's coming from. Unfortunately, there was a problem with the Hansard. It didn't capture, I think, what it thought it would capture. What it captured was the by-election, and that's what we handled. Because he had a little bit of discussion with me yesterday, we are due to present this report, and I said that wasn't captured. But whatever it is, we are ready to review whatever this House directs us to do. Because in the report, we're also noting, Right Honorable Speaker, that there are really some aspects in our considered view which we think should be reviewed. For example, how does a House of 500 members conduct its business? Was that envisaged under our rules of procedure? Maybe not. So we have to think out of the box to see how we conduct business. So right, sorry, I concede. Let the my problem is, even tomorrow, I'm not so sure whether they'll be able to comprehend and even look at the other aspects. So if it may please the speaker, they might need a few more days other than 1 day.
Chair, thank you for considering, and I'm giving you 2 weeks to present the report. Failure to reconcile by that time, you present as it is.
Sorry? 2 weeks is okay with me, Right Honorable Speaker.
Yeah, a failure to reconcile with this group, then for us we'll continue the report.
Much obliged, Right Honorable Speaker.
Thank you. Thank you. Next item.
Item 5, Bill's second reading, the Electricity Amendment Bill 2022.
Honorable members, The Electricity Amendment Bill 2022 was tabled before this House for first reading on 27th January 2022 and was referred to the Committee of Natural Resources. The committee considered the bill and the bill is now for second reading. Honorable Minister of Energy and Mineral Development. Honorable Minister. Can you move the motion, Honorable Minister?
Entitled, the bill entitled the Electricity Amendment Bill 2022 for the second reading. Be read for the second time. I beg to move.
Is the motion seconded? Is it seconded? Seconded by Silwanyi, Attorney General, Honorable Musa, the Prime Minister, Honorable Senu, everybody, Esther on the other side, Aisha. Is that Aisha? Honorable Aisha. By Charity, congratulations for the promotion. Yes. Thank you. Honorable Minister of Energy, pardon? Would you like to speak to your motion?
Right, Honorable Speaker. The objects of the bill are, the objects and principles of this bill are to amend the Electricity Act Cap 125 to provide for a staggered term of office for the members of the authority, to provide for additional functions of the authority, to increase funds allocated to the Electricity Regulatory Authority from 0.3 to 0.7% of the revenue received from the generated electricity energy, to empower the minister to prescribe the procedure to transfer of generation assets to the government, to prescribe the circumstances under which a holder of a generation license or a transmission license may supply electricity to persons other than a bulk supplier, to provide for the deterrent penalties for theft of electricity and vandalism of electricity facilities, to provide disputes tribunal, and to provide for the related matters. The proposal to amend the Electricity Act Cap 145 is intended to remove inconsistencies in the law and introduce flexibility in its implementation and to streamline operations of the electricity sector. I wish to submit.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I wish to lay on table the minutes and the documents on the Electricity Amendment Bill 2022. Right Honorable Speaker, as leaders, part of my work is to provide mentorship, and today, for that purpose, The deputy chair will be presenting the report, and I come in later to handle the amendments. Deputy chair.
Right Honorable Speaker and colleagues, for the record, I'm Dr. Emily Kugonza, Member of Parliament for Buyanja East County in Kivala District, and also Deputy Chairperson, Environment and Natural Resources Committee. Honorable Speaker, Right Honorable Speaker and honorable colleagues, I beg to present a report of the Committee on Environment and Natural Resources on the Electricity Amendment Bill 2022. The committee considered the bill in accordance with Rule 189C of the Rules of Procedure of Parliament. The Electricity Act Cap 145 was enacted in 1999, and there are new development and changes in the electricity sector. The current law does not effectively address issues of institutional compliance and adequate penalties for safety and electrical energy and vandalism of electrical facilities. It has therefore become necessary to amend the Electricity Act to fill the existing gaps and remove inconsistencies in the law, introduce flexibility in its implementation, and streamline the operations of the electricity sector.
Yes, Mota.
Madam Speaker, thank you for the opportunity. Madam Speaker, many of us have our iPads still being worked on, uploaded. Madam Speaker, in the past, they were displaying the report as a member presents, and coupled with the fact that the doctor is so fast, would we be proceeding right if we continue in that way? Could it be possible that they display the report so that for those of us who do not have our iPad, we can follow? And the doctor to slow down, please. Rapping.
But I haven't realized that he's fast. He's not fast. Just display the report. Continue. That's how he speaks, and that's why he's a doctor.
Thank you, Right Honorable Speaker. The report was uploaded, and I believe, and I'm only giving just a synopsis, and because I believe everybody has gone through at this particular time. Right Honorable Speaker and honorable colleagues, a comprehensive analysis, observations, and recommendations to the bill are contained in the report. I will, however, make a brief remarks on some of the pertinent observations and recommendations made by the committee. 1. Funds of the authority. Clause 5 of the bill seeks to amend Section 22 of the Principal Act by substituting the figure 0.3 with the figure 0.7 to increase funding to the authority and to provide for an additional funding to the authority. The committee noted that the authority currently has a funding gap of 8.3 billion. The committee further noted that in assessing the resource needs of the authority, the tariff has been forecasted in line with the ongoing efforts to reduce the tariff for manufacturers who consume nearly 70% of the energy demand in the country to $5 per kilowatt, and energy sales are projected to increase by 11,203 kilowatts by 2024, and thus a level of 0.7% on generation revenue has been applied, and as such, the authority would be able to achieve financial sustainability in the long run and ultimately lower the tariffs for all consumers. The committee is in agreement with the proposed amendment, and a more detailed analysis of this clause is contained under paragraph 6.3 of the report. 2. Energy Development Fund. Right Honorable Speaker and honorable colleagues, the electricity supply industry has a significant deficit in transmission and distribution infrastructure. The committee observed that the transmission and distribution networks require an estimate of United States dollars 2.5 billion and United States dollars 1.5 billion in new investments respectively to repair and rehabilitate the network. This level of required financing is so high and would require additional loans to achieve, which is not sustainable for Uganda. This therefore creates the need to establish the Electricity Development Fund, with funding largely coming from monies appropriated by Parliament, surpluses of the authority, and any other grants, donations, and gifts. The committee contends that creation of the fund will help to provide financing for electricity infrastructure like transmission and distribution of grid network infrastructure. This would boost demand for electricity, leading to a further reduction in the distribution tariff and ultimately raise profitability of the sector companies as they sell more units of electricity and increase the economies of scale. It is therefore this committee's recommendation that an energy development fund be created to paragraph 6.31 of the report for a more detailed analysis. 3 is bulk supplier. Right Honorable Speaker and honorable colleagues, clause 14 of the bill seeks to amend section 56 of the Principal Act to remove the circumstances and may supply electricity in bulk to a holder of a distribution license or directly to a specified class or category of customers. The committee, among others, recommends that the supply of electricity to a specified class or category of customers be open to a more detailed analysis of this clause is contained under paragraph 6.4 of the report. Vandalism. Right Honorable Speaker and honorable colleagues, the committee noted that clause 19.6 to amend section 85 of the Principal Act by providing for deterrent penalties for vandalism of electrical facilities. The committee observed that UETCL spends on average over Uganda shillings 600 million per annum to repair vandalized towers on the existing lines across the country. Given the current rate of vandalism and the growing size of the transmission lines, these costs will increase unless the vice is contained. The committee is therefore in agreement with the proposed amendment to increase the penalty for interference with meters and electrical lines, vandalism, and illegal connections from 100,000 Uganda shillings or imprisonment of 1 year to 4 million Uganda shillings or a 10-year imprisonment or both for receiving vandalized electric facilities, repeat vandalism, and interference with electrical works. More information can be obtained from paragraph 6 and 6.7 and 6.8 of the report. In conclusion, Right Honorable Speaker and honorable colleagues, energy, especially in form of electricity, is a major driver of socio-economic transformation of any country. For Uganda to transition from a peasant to an industrialized economy by 2040, there is a compelling need for increased electricity production to drive the economy. Vision 2040 aims at 80% grid coverage and electricity generation at 41,708 megawatts. However, for this target to be attained, the existing challenges in the electricity sector, such as high tariff rates, dilapidated distribution networks, and unreliable power supply to customers, must be dealt with. The Electricity Act 1999 has been in existence for over 20 years. Therefore, its review is long overdue. The Electricity Amendment Bill 2021 is intended, among others, to address the high tariff rates, remove monopoly of the bulk supplier, prescribe circumstances under which a holder of a generation or transmission license may supply electricity to persons other than the bulk supplier, render all renewable energy projects liable to payment of royalties, curb theft and vandalism of electrical facilities, in addition strengthening the regulatory function of ERA by increasing its funding. With the proposed amendments, we strengthen the legal, regulatory, and institutional framework that is pertinent in improving the electricity sector. This is, in the long run, will help Ugandans to maximize electricity benefits for social and economic transformation. I beg to report.
Thank you so much, Honorable Chair of the committee. You've heard the report, and I now open the report for a debate. Yes, Jen, Milton.
Thank you, Right Honorable Speaker. Right Honorable Speaker, allow me to thank the Deputy Chair and the entire team of the Natural Resources Committee for this elaborate report. Right Honorable Speaker, I want to agree with the committee on the clause on vandalism. Right Honorable Speaker, why I want to agree is not just about the issue of the risk at which our people are put into, Right Honorable Speaker. Right Honorable Speaker, however much we support and pass laws in this parliament, we must put at the back of our mind the enforcement bit of it. I want to pray that as we pass this bill today, Right Honorable Speaker, that the people we have entrusted with the responsibility to undertake the enforcement must do their work, Right Honorable Speaker, if we are to save this country from repeated such acts, Right Honorable Speaker. Otherwise, I support the report. Thank you.
Thank you so much. Milton.
Thank you very much, Right Honorable Speaker. Right Speaker, I have to thank the committee for the good report, and also emphasize the issue of increasing the penalty on people who've been vandalizing the network materials. Right Honorable Speaker, with the emergence of scrap dealers, the emergence of steel mills, so many people have been dealing in electricity equipment, vandalizing meters, vandalizing transformers and poles, dealing in them as scrap. So by us reviewing the penalty, I feel it's the way to go, and it's so deterrent. So I have to agree with the amendment. And if it were possible, instead of 4 million we are talking of, we would even make it 5. It would be more deterrent. I thank you.
Thank you.
Thank you, Madam Speaker. I'd like to take this opportunity to thank the committee for the report. One of the issues raised is on the establishment of an energy development fund, which is a very welcome idea. However, we need to take ourselves back on the HIV/AIDS fund, which was established by an act of parliament more than 5 years ago. But to date, this has not yet been operationalized. So we need to ensure that we don't just establish it, but we have the Ministry of Finance making commitments to ensure that it is operationalized. Secondly, the penalty given from 100,000 to 4 million, I would like to seek clarity on it, because at times the value of what has been vandalized is more than the 4 million shillings itself. And I thought therefore that we could put the 100,000 or the 4 million as a minimum, and instead you give a provision for an upper limit. Lastly, on the renewable energy projects, I need some clarification. It's indicated that they're going to be charged royalties. Is that going to have an impact on the renewable energy such as solar that is used? Because then if it's going to impact on the pricing, then that will become a big concern. I submit. Otherwise, I thank the committee and I support this amendment.
Thank you very much, Right Honorable Speaker. Right Honorable Speaker, this country has a problem of respect to public property. Just for those of us who drive on the express, the Entebbe Express, UNRWA tried to have a chain link along that road. It has all been vandalized. The entire stretch. And if you don't drive properly, a cow might just come up there and cross the road, and you can imagine what will happen. The public does not respect public property. The area will come up with very, very strong measures. 4 million shillings is on the minimum. We need to be deterrent enough. I would really think Honorable Moma is making a point that 4 million, which the minister and the committee are proposing, is on the lower side, especially when the property being vandalized is even more expensive than the 4 million shillings. So, and what do they do with this? They just get the very expensive materials of property and go and make some. Look at what goes on with the solars along the highways. They have been vandalizing the batteries. So I think it is the time, first of all, to standardize anybody who is vandalizing public property, to send a clear message to whether it is the UMEME, whether it is KCCA, whether it is UNRWA, whether it is whichever. No vagabond should vandalize our property, which we have spent a lot of money to put up. So I would propose at the right time, Honorable Speaker, that the amendment, we should do an amendment to increase from 4 million to a minimum of 5 million.
Yes.
That's what it should be, a minimum of 5 million. But at the committee stage, you shall be moving. Lastly, Right Honorable Speaker, about funds. I don't see the Minister of Finance. You see, it's no use creating funds and there are no funds. We had the same problem with even the land fund. How much have we been putting there annual and so on? Very little money. We also have the same problem of management of those funds. You had the petroleum fund, and sometimes when we are having problems, we sneak into that fund and use money for other purposes other than the intended one. So we need an assurance that if we are creating a fund and it's for energy, it should. Any public officer who uses that money for any other reason should be held responsible. We need to put it in the law so that these public officers don't misuse that fund. We are here enacting funds for a particular purpose. Why should a public officer divert that money and it is used for a particular purpose? I thank you, Right Honorable Speaker.
Thank you. Where is the Minister? The Prime Minister. Okay. Haji Yusuf.
Thank you very much, Honorable Speaker. Honorable members, we are falling into a trap of legislating, making laws, create a situation where raising fines and fail to appreciate the situation on the ground. The matter to do with vandalization of UMEME equipment and any other public property has to do with our failure to address the issues of the users. For example, we're involved in a line to do with power, and out of it's about 4.6 kilometers. We're only having only 4 users. Why? Because the people cannot afford it. So they have no reason to protect your property. If you're talking about the chain link on public roads, there's no provision for the poor people to access their homes. So if it is vandalized, actually for them, they are happy because they are not really benefiting. So we should really look out for a way of involving the communities in matters to do with issues to do with public services so that they feel part and parcel. If the entire village, you only have 2 people who can access and afford power, I have no reason to protect your power line. So whether you create fines, you will not have the capacity even to arrest the culprits. Him or her and defend public property. So it is now it's our responsibility as representatives of the people, not just create sort of a class society. Let us try to involve and let people benefit from public property for them to protect public properties. I think that is what is lacking. Otherwise, I support the amendment and the law, but with that kind of consideration as policy makers. Thank you.
Thank you, Right Honorable Speaker. I stand to support this bill for the reasons that they are seeking to remove the monopoly that's now. Right Honorable Speaker, any form of monopoly is not healthy for this country. And as I wait to reject the coffee agreement tomorrow, allow me applaud the committee for a job well done. Thank you.
Shadow, you will come last.
Thank you, Right Honorable Speaker. Allow me to thank the committee for the great work you have done on this bill. I want to discuss on the issue of increasing funding to the regulator. And I want to appreciate the committee for having realized that the regulator has had a big challenge. The regulator has been, and he is, an arms chair regulator sitting in Kampala to regulate the entire country. And most of the times, there have been a lot of challenges coming from the consumers, especially on the issues of power outage. And the response rate has been very low and attributed to low funding of the regulator. So I am very appreciative of the fact that this has been noted by the committee, and they have recommended the funding at least to increase from the 0.3 to 0.7%. But my question to the committee still is, with the funding gap of over 8 billion, I would love to know whether the increment from the 0.3% to 0.7% is able to gap up the difference. Otherwise, thank you so much. I appreciate the committee's work. Thank you, Right Honorable Speaker.
Solo.
Right Honorable Speaker, I thank you very much for giving me this opportunity to talk about this bill. I'm Geoffrey Kayemba Solo from Bokoma Simbi South, and I'm going to speak as a layman from Chiriamemvu. My question is, why does the government, why do people pay connection fee? Yet the government gets money out of your car they use. And most people give out their land for free to put in poles. But during time of connection, they want money for them to be connected. So I think my proposal would be, the connection would be free so that the government can get more taxes out of their car people use, and even this unused, is used. I beg to submit.
And indeed, you have talked as a layperson. Yes.
Thank you. Thank you, Madam Speaker. Thank you, Madam Speaker. Namanya Nabos again is my name.
for record purposes. Madam Speaker, I support the bill. In my constituency, Madam Speaker, in Ruabo particular, it has become a habit for the public to come and vandalize electricity. Of recent, thieves came and vandalized the electricity lines, and when it was valued, it was over 84 million Uganda shillings. So, Madam Speaker, I think it is prudent that we put heavy punishment to vandalism of electricity. Madam Speaker, a transformer of power is far much higher than the 4 million which is proposed here. I would propose that the punishment should be equivalent to the value of what has been vandalized, Madam Speaker, so that the public can start respecting public facility. I thank you, Madam Speaker.
And members, you're supporting the report now, not the bill. Yes, Doctor.
Thank you, Right Honorable Speaker. I raise to support the report. Madam Speaker, they have proposed to bring down the tariff of those in industry to 5 cents per unit, which is a welcome direction. But the people of Uganda, the ordinary people, they don't have electricity. Yet this nation have constantly listened from the president, telling us that we have surplus electricity in Uganda. Madam Speaker, last week, I lost in my constituency a lady, an old lady, that was attempting to remove a wire from the pole of electricity because she was tapping in the morning. The wires pass everywhere, the connections. Our people don't have electricity. And one of the reasons why they don't have electricity is because the tariffs for home consumption are so high. While I welcome the idea, the amendment that we should reduce the tariffs for the industrial people, I'm looking forward to a day when this parliament will be given us an opportunity that we make suggestions.
Doctor, that is provided for in the clauses, in the amendments. It's provided for. You'll get it.
Yes. Thank you, Most obliged, Madam.
Martin, you have information?
Yes, Madam Speaker, with all due respect given to your capacity, my colleagues, I don't know sometimes how things stand upside down. In Busia, Uganda, we have a village called Sophia. Village called Sophia, almost 70% don't have electricity because electricity in Kenya, which they import from Uganda, is cheaper in terms of tariff than the indigenous Ugandans they are using.
That's what I'm saying.
Therefore, that's the information I wanted to give to my colleague.
Attorney General.
Thank you, Madam Speaker.
Thank you, Right Honorable Speaker.
The Shadow Attorney General.
Yes, and I know my younger brother, although now senior, appreciates, and I want to congratulate you, Madam Speaker, because this is my maiden speech upon your ascension to the highest office. Having looked, I want, of course, to applaud the committee, especially when they went into suggesting an energy development fund. Because our biggest challenges in the electricity sector are largely two: the efficiency and the security. I come from a constituency which has 2 power stations. Of course, one of the power stations became obsolete and it has never been repaired. It was built by the colonialists called Mazavagoji Power Station. The last one that we have has been constructed by a private company, the Sri Lankans. But the biggest challenge I have is that my constituency is the least served in terms of electricity penetration. We only see wires evacuating power to the national grid, and we don't get. Kisoro district, which is part of Kigezi, gets its power from Rwanda. When the president of Rwanda gets annoyed with Uganda, Kisoro remains in the darkness. Cover where you come from with the power station that generates 6 megawatts, cover indeed because of lack of industries, uses less than 5 megawatts. But it has power fluctuations on a daily basis. I will give you.
Right Honorable Speaker, I want to give my colleague information. In my constituency, in 2011, government constructed a mini power station in Buseruka sub-county on River Wambavia. But the community around in that sub-county have never benefited. And that's why people vandalize, because they don't see any benefit. I thank you.
So, for members who seem to be looking at this law from the penal section, I beg that you look at the wider problem. How do we ensure that our people access electricity before you talk of penalizing them? So we had the Rural Rectification Agency. I am one of the happiest people that it was disbanded, because it was only catering for the interests of those who would approach the officials known. Can we have a deliberate move to extend electricity to all areas of Uganda, and then reduce the tariffs, and then talk about penalizing those who vandalize what we have delivered? But if my people remain in the darkness, my people now start digging and using and treating the dams because they don't see the benefits. We are talking of environmental protection to minimize the use of wood for electricity and the like. Unless we really look at extending this power, which you now claim you overproduce, but it's not anywhere. And even those areas have power fluctuations. We will make these laws that will not benefit the common man. I beg to.
Honorable Nwagaba, the access of electricity, the presumption is there is electricity in most places, though not fully there. But then we are making these laws for us to penalize people who misuse electricity in where it is. Just imagine where they are saying somebody just went and is tapping illegal connections. We should have a law that regulates that. The other thing that we will discuss is how do we have electricity in each and every village at lower tariffs. That's what now we shall talk about. Because this law even talks about the tariffs, reduction of tariffs for the local people. It talks about it. When you go to the clauses, you will find it. The upper line.
Thank you very much, Honorable Speaker. Thank you very much, the Right Honorable Speaker. I would also like to thank the committee for the recommendable work. Again, I want to seek clarity on the issue of paying royalties. Honorable Speaker, the committee has recommended on clause 15, where they are saying that renewable energy.
Let's not go to committee stage. First discuss the report.
Okay, Honorable Speaker.
Annette.
Thank you, Right Honorable Speaker. And I want to congratulate you in that seat because I've not been here before. I want to support or second the report that was put forward. But then from Uganda district, I want to take an example of Bukungu landing site, where the Prime Minister even happened to visit, where 2.5 billion was injected in a nice plant, and people came and vandalized the generators that were set up. Was that really due to lack of power, or it was just out of moral decadence? I want to agree with the committee that the report that was written to penalize, let it continue, and perhaps the penalty should be unequivalent to how much what has been vandalized costs. And then two, in Bukungu, we had one gentleman who came up.
Honorable members, I don't want to discuss about constituencies. Let's look.
Right, Honorable, allow me. It is not
in general terms, what we should do, how we should amend the law to protect the users, to reduce the cost of the tariffs, and then to protect those people like cutting wires and
Right, Honorable, let me pass it clearly. I'm most obliged, but allow me pass this. I also humbly appeal that perhaps we should also increase the funds of the legal aids, because this one gentleman came up on behalf of the government and he was not supported because he was dealing with it as an individual and the cutters of the government. Thank you.
Thank you, Madam Speaker. Thank you. Thank you, Madam Speaker, for the opportunity. I want to thank the committee for the good work they have done, and specifically I want to support their recommendations on page 18 on VAT rate for domestic consumers. They made very pertinent observations. One of their observations was that URA stands, okay, URA made more corrections when the rate of VAT was brought down from 18 to 10%, because they made power affordable. Number two, they also made an observation that they noted that the policy, when combined with other sector efficiency measures, it would clear, meaning that affordable electricity would clear the deemed power in the system, further saving hundreds of billions. Madam Speaker, those observations bring us to one question, which is the same question you've been asking. How can we make electricity cheaper? Already we have been notified that bringing down the VAT rate made electricity cheaper and affordable, and more revenue was collected. Madam Speaker, I stand to ask, how about this parliament during this budget process? We allocate funds towards the electricity connection policy, because apparently the funds that were there in the last financial year were depleted, and since then the project has been stalled. I will give you an example that in the rural areas where the Rural Electrification Agency extended power lines, there has been failure to connect these lines to the end user, and actually that has brought vandalism. Myself, they vandalized 2 electricity lines because for almost 1 year we've had these lines installed, transformers installed, but because the connection fees of 2 point something and 700 are expensive for the end user, there has been no connection. Therefore, I stand to support the observations, the recommendations that the recommendations on VAT. I stand to support the recommendations on VAT, that VAT be lowered to from 18 to 10% on domestic consumers. I also highly recommend, and I support the recommendation that VAT be zero rated for the cost of new connections. But I also ask Parliament and the budget team that we find funds in this budget to deal with those power lines that have been extended, but there is no connection that is ongoing, so that we can have the connections made and possibly recover from the revenues that we will get from the electricity that we sell to these consumers. Thank you so much, Madam Speaker.
Thank you, Madam Speaker. I want to thank the committee for the good report. However, Madam Right Honorable Speaker, A lot has been said about vandalism of transformers and others. I'm looking at it from a different angle. As a scientist, and more so a doctor and a professional, we look at prevention as a better thing than cure. When you look at the way the engineers do their work, there is one aspect that is normally left out, and that is prevention. In our rural setting, most people need electricity, and I agree with whoever is supporting that idea. But the question is, how can we prevent the criminals from vandalizing things like transformers? In my opinion, other than pushing for a penalty, extra mile, and see to it that those transformers that are put there are well protected, because as we look at them today, it is very easy for anyone That is my opinion, Madam Speaker. Thank you.
Yeah. Thank you, Right Honorable Speaker and honorable colleagues. I rise to thank the committee chair and the entire committee for a work well done. I support the report and the bill from three perspectives. First is the provision of financing for the regulatory authorities. Sufficient resources for the regulatory authority will help them be able to do their work well. And we really pray that once these resources are made available, they'll be able to do a good regulatory work. Second is in the breaking of monopoly of generation and supply of power. A case in point for West Nile is when a record that because this is the only supply of power has made the people of West Nile be in recurrent power outages. We pray that with the breakage of monopoly, we'll be able to see to it that more suppliers, producers of power will be able to improve access to electricity for the common men and women. Lastly is in the area of theft and vandalism. Whereas on the one hand, I do support the penalties the citizens vandalizing their own assets. So that by understanding the root causes of vandalism, apart from penalties, we will also be looking at public education for them to protect these valuable assets. I thank you.
Thank you.
Thank you so much, Right Honorable Speaker. For the record purposes, my name is Anthony Esenu. I want to go on record to thank the committee.
Let's limit the debate. Let's use 2 minutes.
I want to
We
thank.
still have a long way.
Thank you. I want to just to comment on one aspect in the area of the tariffs that we have proposed. I think it's a good idea, but I'm concerned. I need clarity on the two aspects, on biomass projects and the solar projects. If these are for commercial based projects, I would have no problem with that. But if they are going to address projects which are generating power for own use in people's homes or premises, I would beg that that be given an exception so that we can encourage as many people as possible to get their own power supplies and avoid being charged an extra fee. Thank you.
Thank you. Thank you, Madam Speaker. For the record, I'm Isaac Ismail Otim Giu from Pajere County, Nebi District. Madam Speaker, I support what has been laid on table today, presented. On the issue of vandalism, I wanted to bring out an issue on why some people resort to vandalism. Madam Speaker, up to date, we've got a number of people who have not yet been compensated on their land, where these transmission towers and also those poles have stood. Despite various applications to the Ministry of Energy, this issue has not been attended to. In my constituency alone, I've also put a lot of those issues, but we do not support it, and I condemn it, the issue of vandalism. But I think we need to be able to pay these people, because usually when transmission lines are running, the money has already been allocated. I do not see the reason as to why we have to delay compensating some of these people. And lastly, on the issue of the monopoly, I do support this very much, because it is the main reason why the electricity is very expensive. If you look at the issue of Omeme, if Omeme is receiving electricity at 288 shillings and selling it at 974 shillings to the consumers, that is a very big margin. I know they'll try and bring up the issue of deemed energy and energy losses, also incurring loss which are being covered, but this is still a very big margin. And I support that more companies should come in and try and regulate so that the prices reach our consumers at a less price. I submit. Thank you very much, Madam.
Thank you very much, Right Honorable Speaker. Polika Pogwari from Magule, Palisa County. Thank you very much, the committee, for the report, and I do support as well. One, the penalty. The penalty being given, it's okay, even if it becomes 10 million. But honorable members and honorable speaker, I am not talking in a professional way, because that's my field. There are two ways of stealing or vandalizing electrical equipment or materials. One, a cable that's lying when electricity is not on. I can give you an example, Right Honorable Speaker. In my constituency, 2015, they finished installing electricity. 2017, 3 transformers blew off. We have 12 poles down with the cables that we are trying to protect. Imagine it's almost 5 years those cables are lying down there. Are you going to blame people who are going to sell for scrap? They are poor. Two, a professional person. These people who Umeme staff and Umeme contractors do steal these cables direct, because they know where a switch is, remove the circuit breaker, go and steal, and then take the things. So at the end of the day, I support the penalty to be increased. Number two, we have error. It is the one that is the authority that issues the certificates for the installation, both individuals and companies. But you find that
next.
The Right Honorable Speaker, for the record, Tembo Gideon Mujungu, representing the people of Songora South. Right Honorable Speaker, I speak from experience of over 10 years, having been the management of utility companies in the distribution sector. But I rise on the issue of the cost of electricity to the final consumer. The cost of electricity takes 3 components: the cost of generation, the cost of distribution, and transmission. That adds up to what the final consumer finally pays. Honorable Right Honorable Speaker, I have a view that the cost of transmission could be subsidized or borne by government,
because Uganda Electricity Transmission Company is 100% owned by government. So, in a way, when the government charges the transmission costs, it is charging the taxpayer, the final consumer. In my view, I recommend that we consider subsidizing the transmission cost so that the cost borne by the final consumer can reduce, and consequently, the tariff chargeable to the final consumer will come down. I submit.
Thank you. At the end of the day, we are going to have one single tariff because all those electricity bodies will be merged. Sarah, Stephen.
Thank you very much, Right Honorable Speaker. I want clarification, Right Honorable Speaker. The tenure of office in the report is 5 years renewable, and yet I thought that we had since adopted 3 years, and most of the bills that have been coming to this house have been 3 years renewable. Secondly, Right Honorable Speaker, we all do appreciate that we need electricity in the rural areas. We had the rural electricity levy. Unfortunately, Right Honorable Speaker, REA has since been removed. It's no longer what it was and has since been mainstreamed into the ministry. By having this electricity development fund, because the other electricity levy was helping us, much as the money was going into the consolidated fund. But part of the reason why REA existed was to ensure that it has, extended the electricity to the rural areas to reduce on the rural urban also for the various businesses. So this electricity development fund, once created, I hope it will also be ring-fenced for purposes of equally extending electricity to the rural areas, not just for infrastructure, as I've seen it stated, Right Honorable Speaker, in the report. It is, what is there is that it is for infrastructure, but we want to ensure that it is also, it does the same work as the electricity levy initially. I request to conclude, Right Honorable Speaker. Right Honorable Speaker, the issue of vandalism has been talked about. But this, Right Honorable Speaker, is a serious matter. There is no way an ordinary person can go to vandalize a transformer. These are people who are knowledgeable, they are educated, they have been working with this system, and therefore they know how to remove that transformer oil from these transformers. The penalty must be deterrent to discourage anybody from venturing into that. Short of that, Right Honorable Speaker, we shall pass the law here and the vandalism will continue. Right Honorable Speaker, the issue of REA has to also be discussed. We all know the bureaucracies in government systems.
REA is not part of the bill.
Right Honorable Speaker, it is in the report. It's talked about. And I'm discussing the report. So, Right Honorable Speaker, we need that report on the committee, the select committee on the mergers. I don't know when it is coming, but you all know, colleagues, that in the way that it was operating before. So we need to also have that. We shall not have electricity extended when REA is mainstreamed in the ministry, Right Honorable Speaker. Thank you very much.
I want you to appreciate by the time we constituted a committee on merger, REA had already gone. REA was no longer REA, it was part of the mainstream. And truth be told, we really imagine these people who do the installation. are the same people who go back and steal. They are the same people who go back and steal. So we must have a very high penalty for these people. And as somebody said, you just don't leave a transformer bare. Put it in a bush and you leave it bare. There should be a protection for that. Stephen, Balmoy, Bish, Commissioner.
Thank you, Right Honorable Speaker. Right Honorable Speaker, in the interest of time, I will just tie myself on the issue of vandalism. Right Honorable Speaker.
I am going to send away one member of parliament out.
Right Honorable Speaker.
He has gone.
Right Honorable Speaker, a transformer, the cost unit of a transformer is above 20 millions. Yes, so for us to say that once someone is guilty, maybe he was found stealing a transformer, must pay 5 million and above. This is a great business, Right Honorable Speaker. These people are installing these transformers, they know how to tie them and how to remove them. It is quite hard for a commoner to go in the village down there and remove a transformer. It is quite hard for them. Right Honorable Speaker, protection is better than cure. Rather, prevention is better than cure. We have been seeing how people can be in position to monitor who has tampered with either transformer or something else. We need to have a control unit here at the center. Once a transformer is tampered with in the village there, let these people in the control unit tell that so and so has tampered without transformer. So we can be in position to go and follow up and get that person, and we can at least give a real penalty. Let us have a control unit here in the center. We put a gadget in those transformers. We put a gadget on those wires. The moment those systems are being
Balmoy.
To finish.
Thank you, Madam Speaker, for the opportunity. My name is Lake Sharon Balmoy. I am the woman member of parliament for Gulu district. I want to thank the committee for our report. It was a well elaborate one. Madam Speaker, I think in this country we learn nothing and forget nothing. Why am I saying this? For time immemorial, the electricity poles have been falling down. They put small poles, weak poles, thin poles for that matter. They fall down. Once the rains come, they are gone. The bushmen, when they're clearing the bushes, they burn, the bulbs burned. Some of them burnt them deliberately simply because they say the rich have power, we don't have power. Yet the lines are moving in our gardens. Madam Speaker, I see a lot of money being put on these poles year in and year out. Why can the government think of putting concrete poles? I have seen a few in some places, but most places don't have concrete poles. Why don't we get a lasting solution to this? Instead of buying poles year in, year out, and this money could go to very important priorities such as health, agriculture, among others. So this is one of my recommendations. Secondly, we have what they call rural electrification. You cannot tell me a layman or a peasant in my district, say Gulu district for that matter, cannot afford to pay or buy a pole of 2 million shilling to install power in a one-room house. I would really suggest that the power tariffs be subsidized, especially for the different fee to be paid, which is affordable by the local person back in the grassroots, so that our people get power. In Gulu district, as I conclude, Madam Speaker, in Gulu district, 90% of my people don't have electricity in their homes. And then poles are running in the compounds, on the fields. It really, it's not very balanced. And I think we should, work on this. I thank you.
Thank you so much, Right Honorable Speaker. I would like to take this opportunity also to congratulate you because this is my first time to talk after you assumed that powerful seat. Right Honorable Speaker, I would like to thank the committee for the good work they have done, especially on this bill. But I'd like to bring to attention the members of parliament a few issues. Number one is that I think and I believe there is poor planning in terms of utility companies and the government in terms of installation, because most of the time you find that because of poor planning between utility companies, you find electricity poles placed in the areas where maybe the water is going to pass from, and as such, when the water companies, when the water, maybe national water is trying to construct their infrastructure, they tamper with electricity poles. So I think we need proper planning in this country for us to ensure that everything moves in tandem. Second, Right Honorable Speaker, these days, especially in other countries, you find that they have what we call concrete poles as opposed to wooden poles. In Uganda, we are still using wooden poles and they rot very fast. For example, in my constituency, no.
Silwanyi, then I have leader of opposition.
Thank you. Right Honorable Speaker, I want to thank you and to add my voice, especially in the area, Right Honorable Speaker, where the electricity companies, especially REA, when they are installing electricity or when power gets a challenge, they take a very long time to repair. I have a place that I want to use as an example, Right Honorable Speaker. There is a landing levels came up, Right Honorable Speaker, and this is in Bujiri District, Bulida Sub-County. When the water level electricity poles were consumed. But when these electricity poles were consumed, the electricity body ignored and left this place abandoned, not cared for a period of over 3 years. Right Honorable Speaker, in such a situation, the people now think that I take the information. It is very important, Right Honorable Speaker. Allow me to take the information.
Yeah, thank you very much, honorable colleague, for giving way. I join you in criticizing the report in regard to what you're saying. Okay, in regard to what you're saying. Relatedly, bulk supply has been looked at the side of the providers. It was restricted, you've opened it up, but you're not looking at it on the side of the customers. What they are doing, they are going into small markets, bulking up all the traders in the market on 1 meter, one with a fridge, one without a fridge, then they conflict while paying the bill. The same is also happening with meters. They are bulking them up. But overall, can we have a discussion on nationalizing electricity? Because it's a vital service, just like water is. We should not accommodate private players in electricity, else the cost is going to go up. Let this be the first parliament to discuss the nationalization of electricity as the case was then.
Honorable members,
Therefore,
honorable members, let's not justify the reason for vandalizing. It is illegal. Whether the polls passed in your garden not correct an illegality with illegality. That should not happen. And now we are talking about the cost of connecting from pole to pole, then pole to house, the real electrification. I have heard you talk about 2 million something. Real electrification, the connection is 19,000. The minister will make a clarification on that. Members, we are running out of time. Please. Commissioner, you gave out your time. Can I now hear from the leader of opposition? But you're giving, okay.
Thank you, Right Honorable Speaker. I'll be very brief, but let me commence with an appreciation to you and the Deputy Speaker and all the members who stood with me in paying the last respects to my father last week. Madam Speaker, what is of concern in this report is something on UEB, Uganda Electricity Board, which was unbundled 22 years ago, actually 23 years. That is in 1999. It is still undergoing liquidation. When is the minister completing this liquidation? And have not access to all these assets. Where are the whereabouts of those assets? Another important issue in this report is about the vice of vandalism, which I must say, the report is spot on not to leave it go unpunished. It should receive the highest punishment so that it is a deterrent to the Umeme technical staff who are the ones championing this vice. Thank you, Madam Speaker.
Thank you, Lob.
Thank you, Right Honorable Speaker. I want to appreciate the committee for the report and generally for accepting to absorb and accommodate so many crisscrossing issues. I appeared before this committee and made an official position of the opposition on these amendments. And I'm happy to report that there was good debate and many of them generated a number of emerging issues I have seen in the report. So I want to thank Dr. and his team for being receptive. Right Honorable Speaker, I want to begin with the issue that generates favor in so many people's mind, which is vandalism. Already on our criminal books, there are penalties to those who will do the final drafting, or even before, to look at what those law says and the attendant penalties to avoid making this a penal, to enact a penal section that has a bigger penalty than those in other legislations passed by this House, that we do not have a conflict of laws. Probably you consult with the people who draft the final tidbits. I've not looked at them, but you need to avoid the conflict of laws. Two, Right Honorable Speaker, essentially the bill was on strengthening the actual function of the industry. But I'm glad that the report is accommodating the emerging issues that were not addressed in the bill. And I thought when I addressed the committee that we are missing an opportunity to really do a decent job in addressing key gaps in the sector. And I think this report in a way tries to do that. I want to thank the committee for that observation. And of course, the idea of establishing the Electricity Development Fund. There were concerns that the funds created in other agencies were not working and they didn't have money. But part of the reason was that these funds were created without really run these funds. But for this particular bill and the law that will come out, we are very particular, and I want to invite the House to support that amendment of creating the Electricity Development Fund, because the UEB successor companies are profitable and they normally have surplus revenues. These surplus revenues, they invest at the stock exchange, they buy treasury bills and so on. But while we are borrowing money to finance infrastructure, yet we have money that we are investing in treasury bills and bonds in billions, Honorable Speaker. And yet we come here and borrow for the same purpose. So I think we are taking care of this void in part, yes, but also we shall be able to reduce the borrowing to finance maintenance of infrastructure and expanding electricity. Honorable Speaker, thirdly, the subsequent appreciation of the need to reduce the VAT on the final consumer is appreciated. And this time around, you're right, Honorable Speaker, the domestic consumers constitute about 29% of the overall. The rest are other consumers. But part of the constraint to their enrollment on the grid is the cost, which members have ably discussed. By reducing VAT, because the VAT Act allows for zero rating, it allows for exemption, and we expect now that the Minister of Finance is here, in the tax bills that we are considering under this appropriation undertakings we are making, take care of this VAT variation, at least for domestic consumers from 18 to 10. I can assure you there will be no loss visited on the agents, because it will facilitate enhancement of enrollment and more revenue will be generated than from the VAT. By getting more people on the grid, you'll be able to collect more revenue. Right, Honorable Speaker. Right, Honorable Speaker, and one of the things that I appreciate from the report, initially, the bill had proposed to list the UMEME successor, the UEB successor companies for share sale. Mr. Speaker, these are the very few profit-making government entities that people were prepared to partake of. The rejection of this overture, right, Honorable Speaker, is appreciated. Let's retain some government companies that are profitable to be retained by the government. To scavenge on them should be stopped, and I appreciate the report for that observation. Lastly, right, Honorable Speaker, we initially, part of what informed the gist of the bill was to reduce the bills for industrial consumers, especially from gazetted industrial parks, which the president had promised to be at 5 US cents. And the rest of the consumers were not catered for. And the report, by coming out for equity for all industrialists, is acceptable. That should be the case. Industries are not a preserve of industrial parks. They are everywhere, and therefore we must promote that fairness as proposed by the report. Right, Honorable Speaker, I want to thank the committee and the rest of the members, and I want to support the report, and I wait for the clause-by-clause consideration.
Thank you.
Thank you.
Thank you, Law. And the beauty behind this money that is being increased from 0.3 to 7 is to ensure that we have power at all times. We don't go into a blackout. We have a buffer somewhere that will help us. Members, I now put a question that the bill entitled Amendment Bill 2022 be read for the second time. Those in favor say
The Electricity Amendment Bill 2022, Bills Committee stage. Clause 1.
I put a question that clause 1 stands part of the bill. Does I put a question that clause 1 stands part of the bill. Those in favor say, and to the contrary, nay. The ayes have it.
Clause 2.
I put a question that clause 2 stands part of the bill. Those in favor say, and to the contrary, nay. The ayes have it. New clause. Chair.
Right Honorable Chair, the committee is proposing for an insertion of a new clause immediately after clause 2 as follows. Amendment of section 5 of the Principal Act. The Principal Act is amended in section 5 by inserting immediately after subsection 4 the following subsection. 4A. A member appointed under this section shall have a minimum qualification of a university degree. 4B. At least 1/3 of the members of the authority shall be women. Right Honorable Chairperson, the justification for these proposed insertions are: 1, to provide for a clear academic qualification of a member, considering the nature of the functions of the authority, which require education up to a higher level. 2, in order to cater for affirmative action for women. Right Honorable Chair, I beg to submit.
Minister.
Right, Honorable Speaker, I accept the committee's proposal.
Thank you. I put a question that a new clause be inserted immediately before clause 3 as proposed. Those in favor say, and to the contrary, nay. The ayes have it.
Clause 3.
Chair.
Right Honorable Chair, the committee is proposing that clause 3, which amends section 7 of the Principal Act, be redrafted to provide as follows. By substitution of section 7 of the Principal Act with the following, as follows. A member of the authority shall hold the office for a term of 5 years and is eligible for reappointment for 1 more term only. And the second amendment is that the chairperson and 2 members shall be appointed at the same time, while the other 2 members shall be appointed 1 year later. The justification for these amendments are to clearly provide for a staggered term of office. Madam Chair, I beg to submit.
Minister. Honorable Minister.
Right, Honorable Speaker, I would request Attorney General, he has got an issue on this proposal, and I request him to submit.
Okay.
Thank you very much, Right Honorable Speaker. We agree with the principle of a staggered appointment. However, the way it is drafted now will mean that for 1 year, you will have only 3 members. It will contradict the requirement to have 5 members. So I propose that the clause be redrafted to get the same principle, to say that, to keep the clause as it is, but say, provided the members appointed by the authority for the first, means for the first term, you will appoint the chairperson and 2 members shall hold office for 5 years, and the others shall hold office for 4 years. And eventually after that, it will just become automatic, because when one term ends, the other one will take over.
So you redraft it. How should it read?
It would read, to get to the amendment, and read, provided the members, it will read that a member of the authority shall hold office for a period of 5 years and is eligible for reappointment. Provided for the first term shall hold office as follows. The chairperson and 2 members shall hold office for 5 years, and 2 members shall hold office for 4 years, and the rest should remain as it is.
Yes, honorable members, I put a question that
We're looking at reducing the years to 3 years, Madam Chair, because most standard boards, they have a tenure of 3 years. Making it 5 years, it's quite a long time for one person to be on a board. Madam Chair, I suggest that we amend the Act to 3 years instead of 5 years.
Right Honorable Speaker, the proposal of 5 years, these projects that are not short-term projects. If, for example, you're handling a dam, you're going to be building it for a period of 7 years. So you do not want to constantly be changing the leadership of the authority. So you must have, I'm proposing that we keep it at 5 strictly because of the nature of activities carried out in this sector, which are normally very long-term projects.
honorable members, I put a question on the proposal by Attorney General to amend clause 3. Those in favor say unto the contrary, nay.
Clause 3 as amended.
I now put a question that clause 3 as amended stands part of the bill. Those in favor say unto the contrary, nay. The ayes have it.
Clause 4.
Chair, clause 4.
Honorable Chair, we are proposing to amend clause 4 by inserting a new paragraph immediately after paragraph A as follows. By deleting paragraph 1.
Paragraph
L rather, sorry. And B, in paragraph B, in the proposed paragraph QB, we are proposing to insert the word research immediately after the word consultancies. And secondly, we are proposing to delete the proposed paragraph QC. The justification for these amendments, in paragraph L, we observe that this has been kept in the bill. Secondly, research should be inserted under paragraph QB because it is one of the crucial roles that should be undertaken by the authority. And finally, the insertion of 4QC seeks to take on some of the powers of the minister who hold the role of overseeing and developing the sector. Madam Chair, I beg to submit.
Minister.
Madam Chair, I accept the committee's recommendation.
Yeah, Madam Chair, clause 4 seeks to amend the functions of the regulatory body. And I suggest that paragraph D be amended by inclusion of the word that they should validate the electricity meters. The justification for this is very many Ugandans are uncomfortable with the amount of money they are billed. And in many instances, they feel these meters cheat them. So it should be within the duties and the function of the regulatory authority to validate the meters that we are using. And it's missing in the function. So I suggest that we include it there, the validation of meters to be the function of the regulatory authority. I beg to submit.
By the way, the meters are functions of the Uganda, the Bureau of Standards. It's not a duty of.
Madam Chair, the amendment I'm proposing is to put that noble duty under the regulatory authority of the electricity, because it's not being done. As we talk now, none of the Ugandans has seen anybody taking trouble to validate the electricity meters.
Don't remove the duty from the Bureau of Standards. It monitors the standards and the quality of what is being brought in. Don't mix up the functions.
No, Madam Chair, in my wisdom.
Members, I put a question that clause 4 be amended as proposed. Those in favor say unto the contrary, nay.
Clause 4 as amended.
I put a question that clause 4 as amended stands part of the bill. Those in favor say unto the contrary, nay. The ayes have it.
New clause.
New clause. Chair.
Madam Chair, we are proposing to insert a new clause immediately after clause 4 to read as follows. The Principal Act is amended by inserting immediately after section 17 the following. 17A, Energy Policy and Energy Plan. 1. The Minister shall, in consultation with the relevant stakeholders, develop and publish an energy policy and energy plan which shall be reviewed every 5 years. 2. The Minister shall prepare and publish a report on the implementation of the energy policy and energy plan within 3 months after the end of each financial year. 3. The Minister shall, in consultation with the relevant stakeholders, develop, publish, and review energy plan in respect of coal, renewable energy, and electricity. 4. The energy plan shall take into account the national energy policy. B. The energy plan shall serve as a guide for energy infrastructure investments. C. The energy plan shall take into account all viable energy supply options. And D. The energy plan shall guide the selection of the appropriate technology to meet energy demands. The justification for these new insertions are to cater for the need for a multi-sectoral team to be involved in planning. I beg to submit.
Minister.
Chair.
Yes.
I beg to make a minor amendment. The use of the word energy includes oil and gas. Or rather, for the purpose of this bill, we should retain the word electricity so that it's focused on electricity. But if we make it general energy, it would include oil and gas. I beg to move that amendment. Thank you.
Attorney General. Let's first clear on that.
Right, Honorable Speaker, I get the principle that the honorable member is raising. However, if you keep it as electricity, we leave out others, which we are trying to cover here. Solar, we deal with things. So maybe we could define energy here to exclude oil and gas for purposes of this, for purposes of the bill. Definition of the energy will exclude oil and gas. For this.
I agree on that.
Thank you.
Thank you.
Honorable Polot.
Thank you, Chair. I would like us to be very specific as far as the stakeholders are concerned. Who are these stakeholders? It can happen that the stakeholders can become N in a number. A stakeholder and was not consulted. So it is better we be specific and state who the right stakeholders to be consulted by the minister are.
Yeah, yes, Chair.
Madam Chair, I want to bring the chairperson of budget into context.
Maybe before you bring the chairperson of budget, it is saying relevant stakeholders. Relevant.
The relevant is also relative.
I mean, the law is the law.
Yes, and I think the purpose of relevant is to allow the person who is sitting there at that time, because circumstances change. The person relevant to nuclear energy may not be necessarily relevant to solar energy. So the persons who are relevant at that time will be addressed. I think it gives us enough room to involve everyone whom we can possibly think about.
And when you read it further, it tells you that in respect of coal, renewable energy, and then electricity. So it defines the relevant persons, the relevant stakeholders. I put a question that a new clause being inserted immediately after. Those in favor say and to the contrary, nay. The ayes have it.
Clause 5.
Clause 5, I put a question that clause
Madam
5
Chair.
part of the bill. Those in
Madam
favor say
Chair.
and to the contrary, nay.
Madam Chair.
The
Madam
ayes
Chair.
have it. There was no amendment on clause 5.
But Madam Chair, I have a consideration on that. I have an issue with that. Because if we...
You can go on the committee.
Clause 6.
I put a question that clause 6 stands part of the bill. Those in favor say and to the contrary, nay. The ayes have it.
Clause 7.
I put a question that clause 7 stands part of the bill. Those in favor say aye and to the contrary, nay. The ayes have it.
Clause 8.
Chair.
Madam Chair, clause 8 seeks to amend section 44 of the Principal Act by substituting the words 21 days with the 28 days. The justification for this, Madam Chair and honorable colleagues, is to maintain consistency with the section 43.4.
Honorable Angura, do we have another chair behind? Come and sit here.
Madam Chair, thank you.
Near Sarah. Come
Madam,
and sit and replace the PM.
Madam Chair, thank you for
Yes.
promoting my brother to the front bench. So I was just saying that that clause 8 seeks to amend section 44 of the Principal Act by substituting 21 days with 28 days. And the justification for this amendment is to maintain consistency with section 43(4) of the Principal Act, which provides for the appeal to the tribunal to be made within 28 days after receipt of the notice. Madam Chair, I beg to submit.
Chair, Minister.
Madam Chair, the committee was observant. I concede.
I put a question that clause 8 be amended as proposed. Those in favor say until the contrary, nay. Yes, have it.
Clause 8 as amended.
I put a question that clause 8 as amended stands part of the bill. Those in favor say until the contrary, nay. Yes, have it.
Clause 9.
Clause 9, I put a question that clause 9 stands part of the bill. Those in favor say until the contrary, nay. Yes, have it.
Clause 10.
I put a question that clause 10 stands part of the bill. Those in favor say until the contrary, nay. Yes, have it.
Clause 11.
Chair.
Madam Chairperson, clause 11 seeks to substitute section 51 of the Principal Act. And we are proposing to substitute the words by notice in the Gazette with the words by regulations. The justification for this amendment is that the capacity of limiting megawatts should be determined by the authority through regulations. Madam Chairperson, I beg to submit.
Minister.
Madam Chair, I concede.
I put a question that clause 11 be amended as proposed. Those in favor say until the contrary, nay. Yes, have it.
Clause 11 as amended.
I put a question that clause 11 as amended stands part of the bill. Those in favor say until the contrary, nay. Yes, have it.
Clause 12.
I put a question that clause 12 stands part of the bill. Those in favor say until the contrary, nay. Yes, have it.
Clause 13.
I put a question that clause 13 stands part of the bill. Those in favor say until the contrary, nay. Yeah.
Madam Chair, in clause 14, we on 1, and therefore we are first of all proposing that the head note should read amendment of section 56 of the Principal Act instead of substitution of section 56 of the Principal Act. And so we are proposing to delete subsection L, is 1 rather, subsection 1, and also in B we are proposing to substitute the word circumstances with the word terms in subsection 3. Oh, yes. In the proposed, the amendment we are making is that in the proposed subsection 3, we are proposing 2 amendments. 1, by substituting the word circumstances with the words terms. And secondly, we are proposing by substituting the words or a holder of a distribution license with the words a licensee. C, by inserting immediately after the proposed subsection 3, the following. The terms prescribed in the regulations under subsection 3 shall not provide for undue preference to a specific class or category of customer. is that subsection 1 in the Principal Act is sufficient and it captures and is better captured. Secondly, the amendment in subsection 3 will eliminate the monopoly of a bulk supplier. And finally, the insertion is for purposes of fairness, whereby we are proposing, that is all, Madam Chair. I beg to submit.
Yes, thank you.
Madam Chair, I'm finding use of the word in clause 12 of which we passed. We said the minister shall,
what?
the one we were already passed, we said the minister shall by regulation prescribe. Then when we come down here, we are now saying clause 14 where we are saying the authority may by regulations. So we are having a contradiction. In one clause, the minister to do regulation. In another clause, the authority. I think we need to have uniformity where the minister is the one that does all the regulations in the act. And I've seen that contradiction as we go forward.
Right, Honorable Speaker and the member, yes, the contradictions that seem like contradiction in this are actually intentional. There are certain regulations which have been prescribed for the minister, but the more technical ones have been left to the authority. So to get all of them, because the minister may not have some of the technical capacity for which you want to regulate. So where you find the authority has been given that function, the authority is dealing with, and then the minister is dealing with policy regulation. So you can address point by point, but not a common thread.
Madam Chair, I wanted to advise the AG, because down there...
Eki, what AG is saying, there are some regulations that should be made by the minister and others by the authority, Electricity Regulatory Authority, that you can't give all the powers to one person.
Chair,
there will be an abuse.
Chair, I think I think the minister is right here in the sense that all activities related to performance, day-to-day performance or whatever is related to technicality, that one should be left to the authority, because the minister may not have the technical know-how and can, so I think I have understood it's just purely a matter of management, really.
That's right.
Yes.
Yeah, thank you very much, Chair. I also seek the input of the Land Attorney General on this issue of bulking. Here in the law, bulking is looked at only from one side, that is the side of the providers of electricity energy. Yet in practice, bulking is also
in this clause?
In the definition, and that's what we are seeking to amend. We are amending bulking.
Let's look at one thing at a go.
Much obliged, Honorable Speaker.
Honorable members, I put a question that clause 14 be amended as proposed. Those in favor say to the contrary, nay. Let's have it.
Clause 14 as amended.
I put a question that clause 14 as amended stands part of the bill. Those in favor say to the contrary, nay. Let's have it. Chair, insertion.
Right, Honorable Chair, we are proposing an insertion immediately after clause 14 to read as follows: amendment of section 64 of the Principal Act. Section 64 in the head note by substituting for the words Rural Electrification Fund, the words Electricity Development Fund. B, in subsection 1, by substituting for the words Rural Electrification Fund, the words Electricity Development Fund. C, in subsection 2, by deleting paragraph C. D, in subsection 3D, by substituting for the words rural electrification, the words E, by inserting immediately after subsection 3 a new subsection as follows. The minister shall lay before Parliament approved annual estimates of revenue and expenditure drawn from the fund in accordance with Section 13 of the Public Finance Management Act. Madam Chairperson, the justification for these insertions are: 1, rural electrification program has been mainstream into the Ministry of Energy and Mineral Development. 2, the committee observed that the rural electrification levy intended for rural electrification is currently deposited in the consolidated fund as part of the national budget. The levy currently charged at 5% of the transmission bulk purchases of electricity from generation stations, therefore, need not be charged to the end user consumer. 3, the laying of approval annual and accountability. Madam Chair, I beg to submit.
Honorable Minister.
Madam Chair, I concede.
Thank you. I put a question that a new clause be inserted immediately after clause 14 as proposed. Those in favor say to the contrary, nay. The ayes have it.
Clause 15.
Clause 15, Chair.
Madam Chair, clause 15 seeks to amend section 75 of the Principal Act by inserting immediately after paragraph B the following. C, by inserting immediately after subsection 10 the following subsections. 11, an application for a distribution license shall include a net metering plan for all customer categories. 12, the application shall be granted after satisfying the requirements of metering as provided for in the regulations. The justification for these amendments is that the committee contends that net metering is a standard practice in electricity markets globally. Each distribution licensee should, upon application, make available net metering services to any electricity consumer or captive power generator that the licensee serves. Madam Chair, I beg to submit.
Minister.
Madam Chair, I accept the recommendation of the committee.
I put a question that clause 15 be amended as proposed. Those in favor say to the contrary, nay. The ayes have it.
Clause 15 as amended.
I put a question that clause 15 as amended stands part of the bill. Those in favor say to the contrary, nay. The ayes have it.
Clause 16.
Clause 16, I put a question that clause 16 stands part of the bill. Those in favor say to the contrary, nay. Nay. The ayes have it.
Clause 18.
Chair.
Madam Chair, clause 18 Clause 18 seeks to provide for an insertion of a new subsection 83A and 83B. In the proposed section 83A subsection 2, by inserting the words under this act immediately after the words relevant section. B, in the proposed section 83B, by inserting after the proposed subsection 4, the following new subsections. 4, the penalty imposed under this section for purposes of tariff calculation shall not form part of the licensee's allowable regulated costs. 5, a licensee aggrieved by the decision of the authority shall appeal to the Electricity Disputes Tribunal proposed section 83A, subsection 2, the amendment is meant to avoid ambiguity. And secondly, for the penalty to be effective, it should not form part of the allowable regulated cost for the licensee for purposes of tariff calculation. Madam Chair, I beg to submit.
Madam Chair, I accept the committee's proposal.
I put a question that clause 18 be amended as proposed. Those in favor say aye, to the contrary.
18 as amended.
I put a question that clause 18 as amended stands part of the bill. Those in favor say aye, to the contrary, nay. The ayes have.
Madam Chair, after clause 18, we are proposing an insertion of a new clause immediately after of section 85 of the Principal Act. The Principal Act is amended in section 85 by substituting for the words 5 a term not exceeding 1 year or both, the words 20,000 currency points or imprisonment not exceeding 10 years or both. Madam Chair, the justification for this is for consistency with the new insertions in the bill where penalties have been reviewed to match the current situation. Madam Chair, I beg to submit.
Minister.
Madam Chair, I concede.
I put a question that a new clause be inserted immediately. Yes.
Thank you, Chair. I did request earlier, I don't know whether the Attorney General to assure the House that we are not legislating a conflict of laws, given the ongoing revision of the whatever, to assure us that we are safe.
Thank you, Right Honorable Speaker. Right Honorable Speaker, I did say here before, the laws to regulate penalties are set by this Parliament. This Parliament never gave away the right to set any other penalty. So if the law had set a lower penalty and this House feels that for this particular aspect, I need to set a higher penalty, it would. It guides everyone else to be bound by that, but not the Parliament. So there will be no conflict. Parliament is still seized with the authority to set the parameters.
I put a question that a new clause be inserted immediately after clause 18 as proposed. Those in favor say unto the contrary, nay. The ayes have it.
Clause 19.
Chair.
Madam Chair, clause 19 seeks to amend section 85 of the Principal Act. In the head note by section 85 of the Principal Act, the words insertion of a new section 85A. B, by substituting for the words, the Principal Act is amended by substituting for section 85 the following, the words, the Principal Act is amended by inserting immediately after section 85 the following. C, in the head note of the proposed section 85, by substituting for the figure 85, the figure 85A. The justification, Madam Chair, is for consistency with the new insertions in the bill where penalties have been reviewed to match the current situations. Madam Chair, I beg to submit.
Chair, Minister.
Madam Chair, I accept the committee's proposal and substituting the words of the penalty in section 85 with the following: commits an offense and is liable on conviction to a fine not exceeding 50,000 currency points or imprisonment not exceeding 15 years or both. And my justification for that redrafting is the penalty should be brought in tandem with the proposed penalties of the bill to reflect the severity of the vice.
AG, can you redraft for us this amendment?
The redraft is to read that the amendment was interference with the meters and works in public lamps. And at the end of section 85A now is just to add the words commits an offense and is liable on conviction to a fine not exceeding 50,000 currency points or imprisonment not exceeding 15 years or both.
Does it complementary to the committee's?
Yes, it's just adding to the committee's proposal. At the end of the committee's proposal, just add the penalty.
Okay.
Madam Chair, I agree to the proposal of my minister and of the learned Attorney General, because most colleagues here articulated the issue of vandalism as a big problem and the need to have deterrent penalties. So the proposal is actually increasing from 10 years imprisonment to 15 years imprisonment. So I agree to that amendment.
I put a question that clause 19 be amended as proposed by the committee and the Attorney General. Those in favor? Insertion by, yes.
Madam Chair, I concur with the years, but it's not balancing with the fine. The currency points is so low and it says either or. Is how much?
50,000 is 1 billion.
50,000 currency points.
Yes. 1 billion.
Okay, maybe, but it again looks beyond normal, which is impossible. So we shall be tagging what you know you can never charge. You see, when we put a charge, the one paying must have. But most of these vandalizers are like cattle rustlers. They are not. Okay. Okay.
Honorable Chair, I would want to believe that a penalty should be deterrent, but most importantly, it should enable government to recover the loss it has incurred upon some of these activities. So it should be something realistic that one can actually pay. Why levy $1 billion on a loss of about 50 million, yet you can charge somebody 60 million. So we need to be careful while handling that.
Chair.
Madam Chair, most colleagues have submitted on this, but I just want to give an example how grave the issue of vandalism is. When one tower, just one tower, is cut down by vandals, the cost of one tower is about 350 million Ugandan shillings. Now, when one tower is cut down, it affects the one on the other side and the one on this side. So for us to propose a penalty of 1 billion, we are just perfectly in order. Madam Chair, I beg to submit.
Yeah.
Madam Chair.
Yes,
The minister and the committee, if you put 1 billion, it will make people to bribe police and then the justice system. It is better we say to recover the value twice. For example, if a transformer is 300 million, then let the culprit pay 600 million. Otherwise, we'll not be able to convict any person because people will bribe their way.
but they are saying the 50 currency points. That is 1 billion shillings. It's 1 billion.
Madam Chair, 1 billion, if somebody has committed a crime worth 50 million shillings and is told to pay 1 billion.
No, we are putting a deterrent measure so that you don't do it next time again.
Maybe to clarify to members, when you're setting up penal factors like this, anyone trying to vandalize electricity or energy infrastructure should know that their likely ending up is in prison. If you give them 50,000, they are capable of paying you. So for us, we are telling you, you steal them, you are not likely to get 1 billion, you'll get 15 years. So it's deterrent. So it's telling you what is my option. It's like telling them the only option you have is to go to prison. So the question is, do I really want to vandalize? It works. But honorable members, the people who are carrying out these activities are extremely sophisticated people. It is not sustainable to believe that a person will take down a tower line and is just simply an ordinary person walking the streets. These people are sophisticated, so we need to deter them from making this a business.
Honorable
Madam
members,
Chair.
I put a question that clause
Madam Chair.
19 be amended as proposed by the committee and further amendment by the Attorney General with additional insertion on penalties. Those in favor say unto the contrary. Nay. The ayes have it.
Clause 19 as amended.
Honorable members, this is not a market. And those ones who are saying, you know, those are the ones who vandalize these places.
Clause 19 as amended.
I put a question that clause 19 as amended stands part of the bill. Those in favor say unto the contrary. Nay. The ayes have it.
New clause.
New clause.
Thank you. Thank you, Madam Chair, for that guidance. Clause 20, we are seeking to insert a new clause, immediate. Clause 19, okay. Insertion
After
of a new
19,
clause.
you have a new clause.
We are proposing to insert immediately after clause 19 a new clause as follows. Amendment of section 86 of the Principal Act. The Principal Act is amended in section 86 by substituting for the words 30 currency points or to imprisonment for a term not exceeding 3 years or both the words 20,000 currency points or imprisonment not exceeding 10 years or both. The justification is this is a consequential amendment following the one we've just made. Madam Chair, I beg to submit.
Minister.
Madam Chair, I accept the committee's proposal.
I put a question that a new clause be inserted immediately after clause 19 as proposed. Those in favor say unto the contrary. Nay. The ayes have it.
Clause 20.
Clause 20, Chair.
Madam Chairperson, clause 26 to substitute section 86 of the Principal
Clause
Act.
20.
Clause 20 is substitution of Section 86 of the Principal Act. Clause 20 is amended A in the head note by substituting for the words substitution of Section 86 of the Principal Act, the words insertion of a new Section 86A. B, by substituting for the words the Principal Act is amended by substituting for Section 86 the following. The following. The Principal Act is amended by inserting immediately after Section 86 the following. C, in the head note of the proposed Section 85, by substituting for the figure 86, the figure 86A. Justification is Section 86 has been maintained in the Principal Act, and so the new provision should appear as an insertion into the bill and not as a substitution. Madam Chair, I beg to submit.
Honorable Minister.
Madam Chair, I accept the committee's proposal to insert Section 86A as maintained in the bill.
Madam Chair, this section seeks to punish even a person who accidentally, maybe by way of driving, knocks down an electric pole. So to subject this person to the punishments we've just been discussing here, it is unrealistic. So this should not be an import of the other punishment to here, because it reads, a person who willfully or negligently causes energy to be diverted from its proper course, or be wasted, or breaks, throws down, or causes to fall, or damages any supply line, post, pole, or any other equipment. I've seen many people driving and they knock these electricity poles accidentally. So we can't subject the kind of punishment we've been discussing to Section 86. It should not be deterrent. It should be a recoverable punishment to recover the loss incurred on government, but not a deterrent punishment.
Are you supposed to drive around the poles?
Madam Speaker, mine is not to levy a punishment of 1 billion on a person who has accidentally knocked down an electric pole. It could be even a mechanical damage. Let the punishment be recoverable, but not deterrent. So let the person pay the damage.
Madam
If it's
Chair.
an accident, that one will be determined at that time.
Madam Chair, and this clause speaks to willful. Willfully is different from an accident, which you are alluding to. So the spirit of the law is different from what you are speaking to. I beg to.
It talks of willfully or negligently. So if somebody didn't service his vehicle, it could amount to negligently.
What is the meaning
but
of
it's very
negligent?
unfortunate.
What is the meaning of negligently?
Madam Speaker, in Uganda, due to circumstances, especially incurred on us by government, sometimes we find ourselves very negligent. Yet we should, but overall, the punishment here should not be deterrent. The punishment should enable government recover the loss incurred.
Doctor, you know, I don't want you to blame Dr. Batwa. Dr. Batwa is a great doctor.
Yeah, let's help.
The vet.
Let's help. He's not a vet.
Let's help the doctor on this matter.
I don't mean Dr. Bed.
I think there are two things here. Number one, for this fine to be given to you, there is a due process. You must go through a due process.
Yes.
You'll go to court, make your case. Number two, an accident is a defense.
Yes.
If you really prove to court that the destruction was occasioned by an accident, court will listen to you. So I think let's not create an impression that somebody will wake up and say, pay the billion or go to jail. No, there is a due process. I think that's what we need to understand when we are talking about penal provisions. Penal provisions don't exist in the abstract.
there is a due process of the law. Will be able to prove their case before a court of law.
There is a defense of an accident. Haji Katuntu.
Thank you very much, Madam Chairperson. To be held criminally liable, you have to take two things into consideration. One, what we call mens rea. You must have a criminal intention, and you put into action that criminal intention, what we call an actus reus. So the prosecution has a duty to prove that actually you had that criminal intention, and you put that criminal intention into effect by doing a particular criminal act. Those are the only two grounds upon which you can be found criminally liable. If you go through that, I don't see any reason why doctor is worried. There is a process, and right, Honorable Chairperson, the proof in any criminal matter, what we call the burden is on the prosecution, the one alleging. But it also has a standard, and the standard is beyond reasonable doubt. So all the safeguards are there within the law, and really, Doctor, your concerns really are misplaced. Just let us have these. Actually, I don't have a mild English word to use, but let us punish these people who really.
Thank you. I put a question that clause 20 be amended as proposed. Those in favor say unto the contrary, nay. Let's have it.
Clause 20 as amended.
I put a question that clause 20 as amended stands part of the bill. Those in favor say unto the contrary, nay. Let's have it.
Clause 21.
I put a question that clause 21 stands part of the bill. Those in favor say unto the contrary, nay. Let's have it.
Clause 22.
I put a question that clause 22 stands part of the bill. Those in favor say unto the contrary, nay. Let's have it.
Clause 23.
I put a question that clause 23 stands part of the bill. Those in favor say unto the contrary, nay. Let's have it.
Clause 24.
I put a question that clause 24 stands part of the bill. Those in favor say unto the contrary, nay. The ayes have it. Panel, you're just there quiet.
Clause 25.
Chair.
Madam Chair, I'm dropping this proposed amendment. I have realized that since the authority consists of 5 members, if we created 2 subcommittees, then one would have 3 and the other one would have 2. So I'm withdrawing that proposed amendment.
So, I put a question that clause 25 stands part of the bill. Those in favor say unto the contrary, nay. Let's have it.
Clause 26.
I put a question that clause 26 stands part of the bill. Those in favor say unto the contrary, nay. Let's have it.
Clause 27.
I put a question that clause 27 stands part of the bill. Those in favor say unto the contrary, nay. Let's have it.
Clause 28.
Chair.
Madam Chair, we are proposing to amend clause 28 in subsection 3 by inserting immediately after the words "in consultation with the Public Service Commission," the words "appointed by the tribunal." The justification is for proper procedure of appointment of staff of the registry of the tribunal. Madam Chair, I beg to submit.
Minister.
Madam Chair, the committee was vigilant. I accept their proposal.
I put a question that clause 28 be amended as proposed. Those in favor say unto the contrary, nay. Ayes have it.
Clause 28 as amended.
I put a question that clause 28 as amended stands part of the bill. Those in favor say aye, to the contrary nay. Ayes have it.
Clause 29.
I put a question that clause 29 stands part of the bill. Those in favor say aye, to the contrary nay. The ayes have it.
Clause 30.
I put a question that clause 30 stands part of the bill. Those in favor say aye, to the contrary nay. The ayes have it.
Clause 31.
Chair.
Madam Chair, we are proposing to amend clause 31 in the proposed section 119A in subsection 1 by inserting a new paragraph immediately after paragraph. In subsection 1 by F as follows: net metering. B, by inserting a new subsection immediately after subsection 2, the following. 3, regulations made under this section shall be laid before Parliament for information. Justification. The insertion of a provision on net metering in clause 15 of the bill warrants empowering the authority to make regulations for the same. Secondly, there is need for the authority to lay regulations before Parliament for information to enhance accountability and transparency. Madam Chair, I beg to submit.
Minister.
Madam Chair, I concede. However, we are here laying off regulations on the floor of Parliament is a responsibility of a minister. The authority doesn't come to Parliament. So I propose we actually, instead of the authority, we say the minister.
Yes. Yes. Reggie? Attorney General?
Right, Honorable Speaker, that's correct. It's the minister who would bring the regulations to Parliament.
I put a question that a clause 31 be amended as proposed by the Minister, Honorable Okasai. Those in favor say aye, to the contrary nay. The ayes have it.
Clause 31 as amended.
I put a question that clause 31 as amended stands part of the bill. Those in favor say aye, to the contrary nay. The ayes have it.
Clause 32.
I put a question that clause 32 stands part of the bill. Those in favor say aye, to the contrary nay. The ayes have it.
Clause 33.
I put a question that clause 33 stands part of the bill. Those in favor say aye, to the contrary nay. The ayes have it. Question had already been put, you can commit.
Pardon?
Question had already been put.
Now, I was ready up, Madam Chair. I beg your indulgence. I needed to, before the question was put, to get the clarification of the chairperson, because our earlier discussion, the chairperson is not attentive Honorable Chair, the import of clause 33 seeks to introduce a new section in the Principal Act to enable successor companies of UEB. I am looking at the report, and I did not see the chairperson rise. If this was part of the discussion where the chairperson and the committee considered to the effect of Clause 33 that sought to empower the minister to float shares in the women successor companies. Chairperson, line, we are aware that these successor companies are public profit-making companies, and allow them to become partly owned by private individuals. Again, it will be a fleecing of the public using the law. Right, Chair, public utilities like power are meant to provide services to the population. And here we are inviting private interest. Hitherto, we are discussing the problem of tariffs to domestic consumers. And the committee moved to ameliorate this by reducing VAT from 18 to 10%. If we leave Clause 33 intact, it will be a very serious abdication of public duty, and it will be an invitation for speculators into these profit-making public companies to buy in shares. Honorable Chair, I would like to invite the House to consider 33 as a problem, and the chairperson of the committee needs to explain to this House where it derives comfort in making no comment on Clause 33.
Lob, what is your proposal? To delete?
To delete completely 33. Because the question that was being put that it remains part of the bill and is problematic, Chair.
Attorney General?
I think, Right Honorable Speaker, I think the law has a point, because in the report it was addressed, but I think the committee, when it was making its presentation, did not raise it. We actually thought he had dropped it. That's why we did not raise it, and I think the committee chair can advise us on where they are with that.
If it's aware.
Yes, that in our recommendation, actually, we made it clear that the committee recommended that Clause 33 be deleted. Unfortunately, when we were extracting the amendments, we forgot to extract this for deletion. So my apologies, Madam Chair. So, and I want to applaud my brother, the Lob, for pointing it out.
Dr. Batua, can you leave my law? Get back to where you're seated.
Lob, I want to applaud you for recognizing that we had actually made this omission, but also for having worked very, very closely with the committee right from the time we were examining this bill.
Honorable members, thank you for being observative, and I put a question.
Madam Chair, I accept that section to be deleted, that clause.
Lob, thank you for the observation. So by Lob to delete Clause 33. Those in favor say and the contrary nay. Ayes have it.
Title.
I put a question that the title stands part of the bill. Those in favor say and to the contrary nay. Ayes have it.
Motion for resumption of the House.
Honorable Minister.
I beg that the House resumes. Resumes to discuss, to debate the report of the committee, of the whole House. I beg to move that the House bill resumes and the committee of the whole House reports thereto.
Honorable members, I put a question that the House do resume and the committee of the whole House reports thereto. Those in favor say aye, to the contrary nay. The ayes have it. Clerk.
Report of the Committee of the Whole House.
Honorable Minister.
Right, Honorable Speaker, I beg to report that the House considered the bill entitled Electricity Amendment Bill 2022 and passed it with amendments.
Motion for adoption of the report of the Committee of the Whole House.
Honorable members, I put a question that the report of the Committee of the whole House be adopted. Those in favor say aye, to the contrary nay. The ayes have it.
Bill's third reading, the Electricity Amendment Bill 2022.
Honorable Minister.
I beg to move the bill entitled Electricity Amendment Bill 2022 be read for the third time and be passed. I submit.
Honorable members, I now put a question that the bill entitled the Electricity Amendment Bill 2022 be read the third time and do pass. Those in favor say aye, to the contrary nay. The ayes have it.
A bill for an act titled the Electricity Amendment Act. A bill for an act titled the Electricity Amendment Act 2022.
The bill. Yeah.
No, you have a right.
Honorable members, the bill has been passed.
Right, Honorable.
Unsettled.
Right, Honorable Madam Speaker and honorable colleagues, I would like to convey my very sincere appreciation to you, Right Honorable Speaker, first and foremost, for being there always with us and for providing the environment for us to pass this bill today. I recall very well that last night you were there with me up to very late, and you personally in your office.
I was not with you.
Right, Honorable Speaker. Right, Honorable Speaker. Right, Honorable Speaker. I must say.
There is a clarification from Kivalia.
Right, Honorable Speaker.
There is a clarification from Busoga. There is a clarification.
Thank you, Madam Speaker. Thank you, Madam Speaker. Madam Speaker, I'm seeking clarification from the chair.
As a Busoga.
As a member, I'm seeking clarification from the chair, Madam Speaker, because we are normally informed that daytime. But the chair has informed us that due to the requirement and the need for the bill, he decided to be with you up to late in the night. So I'm seeking clarification from the chair to clarify those hours and whether actually is equally provided for in the law.
Honorable members, we are late. We left office late trying to process the bill, and there shouldn't be any concern. That's my son. That is my son. And Busoga is concerned.
Right, Honorable Speaker, thank you very much for the clarification. I just want to let honorable members know that members of parliament are actually employed to work 24 hours. So it's not true that the committees can only work during daytime. But that was for humor and to express how much input the right
honorable members
invested.
Anyway, Chair, you first sit. Honorable members, I want to thank you so much for passing this very important bill. And this bill is going to help us so much with the vandalizers, with the people who don't appreciate government property. I really want to appreciate this House for staying up to this long and passing. I want to thank the minister. I want to thank the Minister of Energy. You've done a good job. We must appreciate. I also want to thank the ministers who have stayed around. Honorable Justin Lumumba, Honorable Henry, and education. But most importantly, thank the Attorney General for the legal guidance that he has given. Attorney General on this side and on the other side. And then I want to thank the chairperson of the committee, the vice plus the whole committee. And special thanks go to my leader of opposition. Leader of opposition, you've done a great job. And my shadow Attorney General, Honorable Katuntu, and then my shadow speaker, the shadow speaker. And I want to thank honorable members. I want to thank all of you for passing this bill. It is a very, very important bill for our country. The old woman for staying here longer, thank you for staying here longer. The Miss Uganda, thank you so much. I want to really appreciate what you people have done. It's a very good milestone for the country. I therefore adjourn the House to 2 tomorrow.
What do you call it?